please all rise. Lawrence County Municipal Court is now in session. The Honorable Donald R. Schaffer presiding. All those having business before the court draw near and you shall be heard. God bless the great state of Ohio and this honorable court. You may be seated.
Welcome to Lawrence County Municipal Court. I'm Judge Schaffer. As you can look around, it's pretty crowded today. It's going to be a really busy docket. There was a lot of activity. Sir, please have a seat. Sir, I'm talking, and I want people to listen. You can leave after I'm finished with my instructions. It's a busy docket. Have some patience. There's a lot of new cases, a lot of people in jail. We're going to start with the reviews. That's for people who are before the court on orders to do things. And this is a check to see if you're doing those things. When your name's called, come up to the table to your right, stand there. I'm going to go over your charges with you. Anyone that's out in the lobby that has a review needs to be in here now. If you miss it, you're going to go to the end of the docket. And today, that could be 2 or 3 o'clock because it's going to be a long day. Lots of new cases. Call the reviews, please.
Kevin Bowen Jr., Jessica Christian, Summer Crank, Naaman C. Cox, Buddy L. Hardy, Charles Hutchinson, Oscar Leach.
Kevin Bowen.
Yes, sir.
2350.
Yes, sir.
Okay, you just have $89, right?
Yeah, I got 20 to pay on it today, sir.
Are you working, sir?
Yes.
Okay.
I'm not getting very many hours right now. Like
Does it matter if your hearings are Mondays or Fridays?
No, sir.
Okay. Well, set it for August the 11th. If you finish paying, you don't have to come back.
All right, thank you.
9 o'clock, August the 11th. Jessica Christian. Jessica Christian. She has 3 cases. 183566, 19255, 222505. She's not here, so it'll be a warrant issue. Summer Crank, 25198. So I'm not showing anything's been done on this yet. Have you done anything?
Not yet. I have money to pay on today and my check-ins today.
How much are you paying?
25.
That's not much. In this case, you owe restitution to a person of $520.45.
And
That's not going to get it.
I've barely had a month to pay on it and I don't work.
All right. Holding cell. Inadequate effort. You're going into custody.
Go back to it.
Name and cost. 23,569. 22,1663. 21,3062. How much, how many hours of community service did you turn in?
18.
Okay, very good. Are you paying anything on your phone?
If it's possible that I don't today, it would really help me a lot. I haven't worked for 5 weeks. I've
Okay,
got a shoulder injury at the moment. I have a doctor's appointment tomorrow.
at least you're doing something, so 18 hours of community service is significant. We need to get these finished though. I'll set you for August the 11th also, 9 o'clock.
Thank you.
You're welcome. Buddy Hardy. But he already is here. Just making payments on your funds. Do you have a payment today, Mr. Harvey?
Yes, sir, 25.
All right. See the clerk take your payment, and I'm going to set your next hearing for August the 8th.
August the 8th.
August 8th. Almost exactly 1 month.
Thank you, sir.
You're welcome. Charles Hutchison is here. Got a report from the family recovery. Okay, good screens and good report.
Your Honor, if I may, he turned some community service in this morning also.
Okay, very good. Can you pay anything on your fines?
May I ask how much do I owe?
Well, let's see, 18, 12, 10, that one's paid. 19, 26, 35, that's paid. Maybe you don't owe anything, let's see.
I believe he just owes.
584, $210, so you owe $210
Okay,
on the last case.
okay. I can take
Pay
care of it.
anything on that?
I can take care of it today.
Okay. See the clerk to do that. Good job on your counseling. August the 11th will be your next hearing, 9 o'clock.
Thank you, Your Honor.
You're welcome. Oscar Leach, 25-244. Oscar Leach has been called for, hasn't done anything on his case at all. So there'll be a warrant for failure to appear.
Reuben Mitchell, Derek Newell, John Scott Pfeiffer, James Sarton, William Spalding, Michelle Sturgill, Joe Walden.
Reuben A. Mitchell, 13-39-33. Reuben Mitchell has not appeared. The events weren't for failure to appear. Eric Newell,
Yes, sir.
22-12-29. Okay, you still have community service to do and fines to pay. This is not good. You have to come in.
Yeah, I'm in the Phoenix Center still,
Okay. And you self-reported for that some time ago, right?
yeah, I'm sending I should be out of here in the middle of this month, and then I'll be, I've got everything sent to the probation officer, like you asked me last week.
Okay. I'm going to set your next hearing for August 4th, and I want you to be here in person.
Yes, sir.
9 o'clock.
Thank you.
You're welcome.
You can tell that we wasn't one of the other side. I should call it Schaffer.
Who is talking?
And then be like, there's.
Who's talking? Mute your microphone. John Scott Pfeiffer, 24-216.
Yes, sir.
Okay, you paid your fines off, you still have a couple days of community service.
Yes,
Is that right?
Yes, sir. Your Honor, if I may, he came to community service last Wednesday, and he got sent to Chesapeake, and we got a phone call. It was not good. So he needs to do his community service with us, and he did not get credit for last Wednesday.
Okay, and that wasn't, okay, yeah, it's not showing up, but you didn't give it credit at this point anyway.
Correct.
Okay, you're going to do it here, report to the court for 2 days on any day but Sunday at 7:30 to get your community service done.
Yes, sir.
I'll set your next hearing August 15th.
Yes, sir.
August 15th, 9 o'clock. James Sarton, 24,897, James Hartman. Okay, this is on an OVI. And the driving under an OVI suspension. And you were going to treatment at Hart?
Yeah, I completed, but I'm just still staying for support.
Okay, do you have any kind of report from them?
No, they said they sent one in. They gave me a copy, but I ran off and left it at the house. I was running late this morning.
Okay,
Your Honor, he did turn in 18 hours of community service this morning also.
all right, that's good. I've got a report from them, but not a completion report, so I need when you say you got one, you need to bring that in that shows you.
I can kind of fax it in, or I can bring it in the morning and give it to somebody.
Okay, either way, as long as we get it, just coordinate that with the probation or Mr. Cooper, community service. And you said you're paying on your fines too?
Yeah, I'll kind of pay, when I get paid Wednesday. That'd be fine.
All right, I'll set your next hearing for August the 18th.
Thank you.
William Spalding is here, 23,512. Got 1 day community service and fine.
I'll be, I was out of town most of the month of June, but I'll be doing my community service tomorrow.
Okay.
Get it
Do you
clear
have any
up.
payment on your fine today?
Yeah, I have $25 for that, Your Honor.
Okay, I'm going to set you for August 15th as your next hearing,
Thank you, Your Honor.
9 o'clock. Michael Sturgill, 24,589.
Michelle.
Michelle Sturgill, I'm sorry. I misread it. Michelle Sturgill. You just have fines to pay. You did make a payment today.
Yes, sir.
Okay. August the 18th, your next hearing. If you paid it off, you don't have to be here. 9 o'clock, August the 18th.
Thank you, sir.
Joe Walden, 13,358, 1199, 14,594. Just have fines to pay. Do you have a payment?
Yes, I have 100 today.
Okay. See the clerk, make your payment. I'm going to set you for August the 8th, because of all the cases. So August the 8th, your next hearing, 9 o'clock.
All right, thank you.
You are. See the clerk. Okay, the next hearings are called arraignment, so anyone out in the hallway that's got a new case, and there's a bunch of them today. It's a very busy weekend, so if you have a new case or an old case where you got arrested on a warrant, you need to be in the courtroom, you bond it out. You don't need the pretrials yet, so if you're here for a pretrial and have a lawyer, you don't need to be in the courtroom yet. It's going to be a while before we get to you. Okay, so I'm going to go over your rights, which you've probably heard many times before, but try to do it with a group. And if you have questions about your rights, I'll answer those when your case is called, or go over them again if you want. You have the right to remain silent. You don't have to say anything. But what you do say, anything you say in this courtroom, it's all being recorded. Everything we say here, there's cameras going and audio equipment, it's recording everything. So if you get up and admit something about your case, the prosecutor can use that against you and play it back. So you don't have to say anything. You have a right to talk to a lawyer. That's privilege. That can't be used against you. You have a right to have an attorney appointed if you can't afford one. You have a right to bail, and you have a right to make the state prove any charge against you beyond a reasonable doubt. If you decide you're going to enter a guilty or a no contest plea, you're waiving those rights I just explained to you. You should not waive your rights if you don't really understand what's happening, if you're confused, if you don't know what to do, if you want a trial, if you want to talk to a lawyer, any of those reasons. Not guilty is the plea you should enter, because that preserves your rights. I have people all the time say, I just want to get it over with. Don't enter a guilty plea or no contest plea to get it over with. That's not a good reason to enter one of those pleas, because it's going to go on your record. Call the first case.
State of Ohio versus Austin T. Schaffer, case number TRC 25-1507, A, B, and C. Austin Schaffer.
And sir, are you Austin T. Schaffer?
Yes, sir.
Mr. Schaffer, it's alleged that on June 28th at 12:59 a.m. in Union Township, you were driving a vehicle while you were under the influence of either alcohol, drugs, or some combination of the two. And it's alleged to be the first time you've been charged with this. So on a first offense, the maximum penalty you face is 6 months in jail, $1,075 fine, and a 3-year license suspension. That's the most that can happen. There is a minimum. Most charges don't have a minimum. This one has a minimum. So if you're found guilty, I can't give you less than 3 days in a treatment program, $375 fine, and a 6-month license suspension. That's the minimum penalty. Do you understand that charge and the possible penalties?
Yes, sir.
The state's saying that they've got both, and this is a little confusing to me, so I don't understand. Both the box check for a breath test and a urine test, which that's unusual. Usually you get one or the other, or check, so I don't know what happened. If it is a urine test, it'll take a while to get the results, because those go to a lab for testing, and I don't have any results in the file at this point. The state's also alleging you were driving 54 miles an hour in a 35-mile-an-hour zone. That's a non-jailable speeding offense. Maximum penalty is $150 fine. And that you had a headlight out. That's minor misdemeanor. Maximum penalty is $150 fine. Do you understand these charges?
Yes, sir.
Do you understand the rights you have?
Yes, sir.
How do you plead?
No contest.
If you enter a no contest plea, you're giving up your right to have an attorney to make the state prove his charge beyond a reasonable doubt. I don't have the results back, but on the urine, or I'm looking at the report, it looks like maybe the officer saying you refused to take the urine. So anyway, if you enter a guilty plea, you're admitting that these charges are true, and you're waiving the right to have a trial and have a lawyer. I'm sorry, if you enter a no contest plea, what you're saying then is, I'm not putting up a fight on these charges, I'm not admitting I'm guilty, but I'm not denying it, and I'm going to agree that I can be found guilty without a trial and a lawyer. If the court thinks the evidence the state says it has is enough for conviction. So it usually, 99 times out of 100, it's going to result in a guilty fine. Is that what you want to do?
Yes, sir.
Okay. Well, there may be something that I didn't know that I'm going to see in the report that I'm going to have to. Okay, I've got an impaired driver report from Trooper Beam, who's the arresting officer. Okay. June 28th at 12:59, I had set up Stationary position, 775, mile past 0. Monitoring speed of vehicles traveling that zone. I observed a vehicle traveling toward me, I estimate to be 55 miles an hour, activated my forward-facing radar. Had a clear signal. The vehicle speed was checked at 54 miles an hour. It dropped to 51. I also witnessed the passenger side headlight was not on. I followed the vehicle. It was a black Ford Taurus. Used the license plate number activated overhead lights. Approached the driver's side vehicle, detected an odor of burnt marijuana before I reached the driver's side window. The driver was Austin Schaffer. His speech was lethargic and slurred. I informed him of the reason for the stop, asking for ID. Mr. Schaffer said, "I'm out getting cigarettes." As I talked with him during the stop, I could detect the moderate odor of an alcoholic beverage coming from his vehicle. It also took a bit before Mr. Schaffer made eye contact with me. When he finally did, it was clear that they were watery and bloodshot. Asking him about his alcohol consumption, he said just 1 or 2. Asked him to step out of the vehicle, and he exited, walked in front of the patrol car. He told me he had been drinking shooters. He also told me that he had been at a bar called the Lantern in Huntington. He went through some preliminary questions, see if he could perform field sobriety tests. He said he was not taking prescription medication. He had a history of any head injuries, which he denied. 4 clues on the horizontal gaze and the nystagmus test. That's an alcohol test. 3 clues on the one-leg stand test. Portable breath test. Ask him to give a sample. He said that he had smoked a blunt or 2 of marijuana. The BAC on the portable breath test was 0.36. He was transported to the post, read and shown the MV 2255 form. Was asked to provide breath and urine samples. He was unable to urinate. He was cooperative and respectful throughout the traffic stop. All right, you have any explanation or statement you want to make?
No, sir.
All right, based upon some alcohol and some admitted marijuana use, I'm going to, in your test, I'm going to say there's sufficient evidence for finding you guilty that you weren't here, your ability to operate the motor vehicle wasn't here. Are you employed? What do you do?
I work in Milton at Giovanni's.
Okay. You have proof of insurance, so that's good. Does the state take any position on this something?
No, Your Honor, first offense, and it appears he was cooperative anyway, so we would not have mandatory minimums.
Okay. Anything further you want to say, Mr. Schaffer?
No, sir.
All right, I'll give you a $375 fine, that's the minimum fine. Or you pay the court costs. 6-month license suspension, it'll start the day of the incident, June 28th. It's going to be out on Christmas Day, December 25th. It'll be the last day of your suspension. 20 days in jail, which I'll suspend on the condition that you do the other things you're ordered to do, one of which is 5 days community service. We have a community service program here at the court. You can work any day, but Sunday at 7:30 or a holiday. You can't work on a holiday. Just come here at 7:30 and we'll get you someplace to work in the community. You have to go to a 3-day treatment program. That's mandatory. If I don't give you jail, you gotta go. There's one here in the county, but you can go to any one that's approved by the state of Ohio. There's some cheaper ones, to be honest. I think the one that's the cheapest that I've heard of is the Shell Coffee. It's a couple $100 cheaper than the one here, so it's up to you. It is, those are inpatient programs, so you gotta go stay for 72 hours. I'll set your review hearing for January the 12th of next year. So what the review hearings are under here, we had some this morning. It's a check to make sure people do what they're ordered to do. So I don't want you to go to jail. You don't have to go to jail, but you can still go to jail if you don't do this stuff. And you know, this morning, if you were here and watched, there was people that didn't show up for the review hearings. Every one of them got a warrant. So what's going to happen there is, you know, the sheriff is not going to go beat down their door and pull them out, but the next time they get a speeding ticket, they're not going to get just a ticket. They're going to go to the courthouse because they got an outstanding warrant for not coming to their review hearing.
Right.
So just do what you're supposed to do, and you won't have to go to the jail. Okay, I'll give you, since you do have a proof of insurance, and you're going to have to maintain this, I'll give you a permit to drive during the time of your suspension for work, since you are working, to come to community service, to go to the 3-day program. Anything else you, immersion type driving you need to do.
Okay. No, sir.
Okay, so you'll get that from your probation officer. You're going to meet with Mr. Major. He's going to be your probation officer. Everything I've told you is going to be on a piece of paper called the judgment entry, which he's preparing right now. I'm going to sign, the prosecutor's going to sign it, he'll give you a copy, and it's filed here electronically. And for everyone listening, there's no excuses like, well, I lost my paper, so I didn't know what I was supposed to do. That's not an excuse. Because one, that record is here at the court, and you can actually access it by going to the court's website, put your name in a record search, and it'll show you what you're supposed to do, when you're supposed to do it, when you got to come back to your hearing. So no excuses. I lost my homework. My dog ate my homework. It doesn't fly here. You're going to go to jail if you do that. Okay? It's not just for you, because we got a lot of people listening, but people still do that. They blow it off thinking, well, it's like 7th grade math homework. If I don't want to do it, I don't have to do it. And then you're going to go to jail.
Don't need that.
On your speed offense, I'll give you a $30 fine. And the headlight charge, $10 fine.
Thank you.
Any questions?
No, sir.
Okay, when you walk out the doors of the back of the courtroom, 90-degree left to the west side of the building, that counter over there is probation. Go over there, give them your name, tell them you need to check in, they'll give you your paperwork, and after you've done that, you're free to go.
Okay.
State of Ohio versus Cameron and Carroll, case number 251680.
And sir, are you Cameron Carroll?
Yes, Your Honor.
All right, Mr. Carroll, it's alleged on June 28th, 12:39 a.m. in Tyrie Township, you were driving a vehicle while you were under the influence of alcohol. The state's alleging you took a breath test and tested 12 on the breath test. The per se level under Ohio law, and most states I think now, is 0.8, so we'll just drop those decimal points and say 8. You test 8 or higher on a breath test, and the state can show, this is a big if the state can show they complied with all the rules for giving the test, a presumption attaches to it that you were impaired if you test 8 or higher. State's alleging you tested 12. found guilty of this offense, the maximum is 6 months in jail, $1,075 fine, 3-year license suspension. The minimum is 3 days in treatment, $375 fine, 6-month license suspension. And that's the only charge you have. Do you understand the charge and the possible penalty?
Yes, Your Honor.
You understand your rights?
Yes, Your Honor.
How do you plead to this charge?
Not guilty.
Do you wish to be considered for a court-appointed lawyer?
Yes, Your Honor.
Are you working?
Yes, Your Honor.
What do you do?
I work lawn care in Garrison, Kentucky.
Are you paid by the hour?
Yes, sir.
How much per hour?
$12 an hour.
How many hours a week?
Usually about 30 to 35.
Okay, you're eligible for court-appointed lawyer. You'll have to fill out an affidavit that verifies your income. I'll appoint Mr. Smith. Not guilty plea is entered. He can sign a signature bond, $1,500. As long as you show up, you don't have to post your money, just come to court as ordered. You'll need fingerprinted, so check the box on this bond form where you'll have to go to the Lawrence County Jail and get fingerprinted. It's part of the bond also. Setting pretrials, the 21st or after July.
Let's see. I'm here the 21st, the 28th.
21st is okay?
It is okay, yes, sir.
Okay, let's set it for the July 21st, will be the next hearing. Be a pretrial at 10 o'clock.
And we already have the urine results. I don't know how that happened, but.
I'll show you to the breath. This is Cameron Carroll.
Yes, I've got, this one is from May 24th.
Oh, has he got an notification?
Oh, he sure does. He's got 2.
Let's pull up his name, see if there's
The other one is 25/16/80.
Okay, and Mr. Smith is the attorney on that.
Thought that name sounded familiar, Judge. I was trying to figure it out.
It's set July 21st.
What was that case number? Or that's the same case number?
Oh, this is case number. That's this one. August 1st is when the other one's set. And he said he's going to hire an attorney on that. Let's set a vote for August 1st.
Be fine here then, Judge, yes.
All right, August 1st on this new case. Because the other one we're waiting on urine results, but you have
We have the urine results from the May 24th. The one from June 28th is a breath test.
right.
So we have everything we need as far as that goes.
Well, we can do either date, August 1st or July 21st, Mr. Smith.
So what was that, Judge?
We can do either date. We have the results are back on the earlier.
The 21st, we got the results. Let's just do the 21st.
All right, sorry. Let's go back.
Yeah, sorry.
Change them both to July
Just need to
21st.
pull that file letter for the August 1st docket.
Yeah.
Yeah, go back to 21st. It's not confusing. Our legal system, go ahead, get you in the office, we'll do it, we'll talk, because we got the results back. There's something we got to August.
All right, so July 21st on both cases for the health.
State of Ohio versus Jonathan Morrow, case number TRC 251662, A and B. Jonathan Morrow.
What's it, read it here for you guys. Thank you.
And sir, you Jonathan L. Worth.
Yes, sir.
Mr. Worth, it's alleged on July 5th at 12:52 a.m. in Rome Township, you were operating a vehicle while you were under the influence of alcohol or drugs and that you submitted to a urine test. This is alleged to be a first offense. Urine tests take a while to get the results, so I don't have results on it today. The maximum penalty is 6 months in jail, $1,075 fine, 3-year license suspension. The minimum penalty is 3 days in treatment, $375 fine, 6-month license suspension. You're also charged with speeding, driving 71 miles an hour in a 55-mile-an-hour zone. That's a minor misdemeanor, maximum penalty $150 fine. Do you understand the 2 charges?
Yes, sir.
Do you understand the rights you have as a defendant?
Yes, sir.
How do you plead to these charges?
May I ask a question?
Yes, sir.
How long does it typically take to get the urine analysis back?
9 to 10 weeks.
Really?
So if you're not sure, you probably should wait and see what the results are going to be. And there is no license suspension. If you had taken like a breath test and tested over, or refused to take tests, an automatic license suspension goes into effect. But since your test, you took the test, and we don't know the results, your license is not suspended.
Okay. Might have to go with not guilty.
Do you wish to be considered for a court-appointed lawyer?
I don't think I can.
Okay. Well, one thing you can do in this circumstance, you can wait to see what the results are and then decide if you want to hire a lawyer. Or you can hire one now. I'm not discouraging you from hiring a lawyer, but that would be one thing you can do. We don't know what the results are going to be.
Okay.
And it will be a while before we get the results back. So let's set a date when we think the results may be here. So I'm looking at September the 8th. Does it matter if it's a Monday or Friday for you?
No, sir.
I'm going to set it for September the 8th, and that's a Monday. Hopefully we'll have results then. September the 8th at 10 o'clock will be your next hearing. I'm going to let you sign a signature bond. Signature bond, what that means is you're guaranteeing your own appearance. You're going to sign a piece of paper that says, I promise to come to court as ordered, or I'll pay $1,500 as a penalty, and you get a warrant. So just, you don't have to post any money as long as you come when you're supposed to. So $1,500 signature bond. And we'll have, this is a fairly new thing, so that's why I keep forgetting to say people that go to the jail get fingerprinted automatically. They're wanting, the Attorney General's wanting everybody fingerprinted. So I'm going to make it a condition of your bond. You're going to have to go to the sheriff's office and get fingerprinted, and you'll need a copy of the bond you just signed to take with you to give to them, and they'll do the fingerprints then.
Okay.
So hang around, they'll bring you a copy out, and then be back here on September the 8th, unless you hire a lawyer that tells you they've made arrangements for a different date, and you come on the date the lawyer tells you.
Okay.
Do you have any questions, Mr. Ward?
No, sir.
Okay. Get your copy of your bond paper, they'll bring it to you, and then you're free to go.
Where do you want me to wait at?
In the lobby. Be there.
Okay.
Just wait in the lobby.
All right. Thank you.
You're welcome.
State of Ohio versus Jerry Levens, case number TRC 251661, A, B, and C.
And so you're Jerry Levens?
Yes, sir.
Mr. Blevins, it's alleged on July the 4th at 6:43 p.m. in the village of South Point, you were operating a vehicle while being under the influence of alcohol or drugs, and the state's alleged you took a urine test. So you heard what I said, it takes a while to get those results.
Yes, sir.
I don't have any results today.
Yes, sir.
And the state's also alleging, though, that this would be a second offense for you, that you had a prior in 2021. So that raises the possible penalty on a second offense. The maximum is still 6 months in jail, but the fine goes up to $1,625 fine maximum, and a 5-year license suspension is maximum. The minimum is raised too. The minimum is 10 days in jail, $525 fine, 1-year driver's license suspension, and if the vehicle, and I don't know if it was, if the vehicle's titled to you, there is an impoundment required of 90 days for the vehicle. Looks like there was a wreck here, so I don't know if that's going to apply, but it could if it's titled. Do you understand that charge and the possible penalties?
Yes, sir.
You also got 2 other charges. Driving without a license, that's what's called unclassified misdemeanor. There's no jail time, but there is possible community service. 500 hours community service, $1,000 fine, that's the maximum you can receive on that charge. And then the last charge is failure to control your vehicle, that's a minor misdemeanor. Maximum penalty is $150 fine. So you've got 3 charges. Do you understand the 3 charges?
Yes, sir.
And you understand the rights you have?
Yes, sir.
How do you plead these charges?
Not guilty.
You want a lawyer appointed?
If I can get one.
Are you working?
Not presently. I'm self-employed. I do brick and block work, and I'm kind of in between jobs. I haven't had no work for a couple of weeks.
Do you file an income tax return?
No, sir.
Should you file? Here's what our Supreme Court tells me I have to do. I have to determine your gross income.
Yes, sir.
So that's why I'm asking about an income tax return. What do you think you make gross in a year? All your income together in 1 year, what do you think it is?
I'm gonna say about 8,000 to 9,000.
Okay, well, you'll have to fill out an affidavit to that effect, but you're qualified for court-appointed attorney. I'll appoint Mr. Steyer to represent you. Not guilty plea is entered.
I believe I heard this was a urine screen case.
It is.
So I assume we'll go out a little bit further.
Right.
What sort of a time frame are we looking at? You said
September 8th, when I said the last one I had urine screen.
I'm here, I'm available that day, so September 8th.
September 8th will be the next hearing for a pretrial. He can sign a signature bond, and he'll be ordered to go to the jail and get fingerprinted. $1,500 signature bond.
Sign that. Wait on me out in the lobby to bring you.
September the 8th is the next hearing.
Thank you.
You want to explain to me about when getting fingerprinted?
Yeah, I'll explain. So here's the date to meet on that.
State of Ohio versus Richard Akers, ex parte PRC 251629, A and B. Richard Akers.
Richard Akers. Okay, someone called in and said he was in the hospital. So I'll issue a case piece back to the OSP since it's their citation.
State of Ohio versus Emma Smith, case number TRC 251681, A and B.
Count, you're entering your appearance.
Yes, Your Honor. Good morning.
Morning. you waive a reading?
I do, Your Honor.
You're not guilty plea?
That's correct. We'll be filing discovery today. If we could have the 28th.
July 28th for a pretrial at 10 o'clock. Ms. Smith can sign a signature bond, but she'll be ordered to also report to jail for fingerprinting. A $1,500 LR bond with fingerprint. Take the bond to the jail. Get fingerprinted. July 28th at 10 o'clock will be the next hearing.
Thank you, Your Honor.
You are.
Thank you, Your Honor.
You are.
State of Ohio versus Hunter Tyrie, case number TRD 21-1803 A and B.
Your Honor,
TRC 2491 A and B.
I was just speaking with him out in the hall. I apologize.
Okay.
Your Honor, please the court, I asked him to put it on the docket today. He has been gone for quite some time. There was a TRC case. It was our understanding that was the only case. He has since paid off all of his fines on that, successfully completed the DIP program, has not done his community service yet, but is available to start doing that and has indicated a willingness to do it. So we would ask for the recall of a warrant. Court staff indicated to me today that there's another outstanding charge, however, that we were not aware of.
21-1803 is a driving under a license that was not stated and stop at a stop sign. It's a Hunter Garrett Tyrie with a at Nova Road, South Wilmington.
Your Honor, I haven't had an opportunity to address it with him, but it appears from the officer's narrative in that case that he had indicated he was under the impression that he had a permit through the OVI case, and so I don't know if that had expired. They pulled it and it wasn't there. The OVI case, the final entry, did have that he was permitted to drive for work purposes.
Okay.
So I honestly, I just don't have enough information yet to address that. Sure.
You want to set it for the 28th date or?
Yeah, that would be great, Your Honor.
All right, set it for a pre-trial. Both. Well, one would be actually a review, yes, and the other would be a pre-trial.
What was that date again?
July 28th.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Kendra B. Brown, case number CRB 25221.
You're Kendra Brown.
Yes, Your Honor.
Have you received a copy of the charge?
I have no clue why I'm here, sir.
Okay. Well, we'll get you a copy, and I do not have an extra copy, so I'll have an extra copy in the file. So once you just have a seat, we'll get copies made, and then we'll recall you when we're ready to serve. We need copies of the file. I'll recall you.
Oh, okay.
Okay.
State of Ohio versus Alicia D. Connor, case number CRB 25327 A and B.
And are you Alicia Connor?
Yes, sir.
Have you received copies of the charges?
Yes.
Okay. It's case numbers 327A and B. The A case is alleged that at Rome Township on May 11th, 2025, you knowingly caused or tried to cause physical harm to Cora Harmon. Assault is a first-degree misdemeanor. It carries a maximum penalty of 6 months in jail and a $1,000 fine. 327B is a menacing charge, same time, place, and it's the same alleged complaining party, court harm, that you caused her to believe you were about to cause her physical harm to her person or to her property. Menacing is a 4th degree misdemeanor, maximum penalty 30 days in jail, $250 fine. Do you understand these charges?
Yes, sir.
And you understand your rights?
Yes, sir.
How do you plead to these charges?
Not guilty.
You want a lawyer appointed to represent you?
Yes, please.
Are you working?
I'm off right now for summer vacation. I work for a school district.
Well, you heard what I said before. I have to determine your gross annual income. What's your gross income from the school district?
Probably like around 10 to 12,000 a year.
Is it part-time then, or?
I'm just a school bus driver.
Okay. I'll appoint Mr. Holt. Well, I don't think so. You were not fingerprinted?
No.
Okay, that'll be a part of the bond also. She will need to go to jail, get fingerprinted. And Mr. Holt's going to be your attorney. Her bond will be $1,000 signature bond with, is there a protection order requested?
Yes, we've already had her sign.
Okay. So you're not to go around, is it a problem for you to stay away from Cora Harmon?
I do have a problem.
I've represented Cora multiple times, Your Honor.
Okay, well, let's appoint somebody else then, sorry.
I have visitation that I have to share with my ex, and that is his girlfriend, and every time that we show up to meet, she is there. Or if he calls, she's on the phone. I don't know what to do, Your Honor.
Well, you just have to avoid contact with her while this is pending. Let's get you another lawyer. Are you taking appointments or, okay. Appoint Mr. Morford.
And sir, I have another question too. I have videos and stuff from that day and photos.
Your lawyer.
Okay.
Today's not the trial, so I can't say, oh, you're right, I'm throwing it all out.
I just didn't know who to give them to.
Give it to your lawyer.
Good morning.
Okay, Mr. Morford is going to be your lawyer. She has an assault and menacing charge. So I'm going to order that you stay away from Cora Harmon. So what I want to happen, here's what I want to happen, nothing. I want nothing to happen while the case is pending. I don't want there to be any more confrontations, alleged problems. So stay away from her, don't contact her. Don't post things about her on social media. Okay, that's a big thing nowadays. Just let everything die down. And if she approaches you and you say, I can't be around you, and she keeps coming, you retreat and go call the sheriff.
Okay, that was my next question.
Okay, Mr. Warford, I'm setting cases for July 21st or after. What's your schedule?
Judge, I'm here on the 21st, if you want to do it then.
Okay, yeah, that should still be okay. Let's start to fill up. July 21st will be the next hearing at 10 o'clock.
We have a protection order for her
Yes.
sign also.
She'll also need to get a copy of the bond for them.
She would need to take her bond down to the jail for fingerprints.
State of Ohio versus Kendra D. Brown on recall, case number CRB 25221.
Now we have a copy of the complaint to give to Ms. Brown.
Appreciate that.
The charge is telecommunication harassment. The alleged is April the 6th of 2025 in Fayette Township. You made or falsely made telecommunications from a device under your control with purpose to harass, intimidate, or abuse another person. That is a first-degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. Do you understand the charge?
I do.
You understand your rights?
I do, sir,
How do
yes.
you plead?
I'm not guilty.
You want to be considered for a court-appointed lawyer?
Absolutely, please.
Are you working?
I am a full-time mother of my 2 disabled children, and then I work part-time at Texas Roadhouse.
Okay, so you're working as part-time?
Yes, yes.
So let's try Mr. Holt again. Okay, Mr. Holt, please. This is Andrew Brown. She has a telecommunication harassment charge. You're going to not complete for her. And I believe she has posted a bond. She has posted a bond. So I'll continue the bond you posted. I'm setting cases. Let me check and see. We can still do the 21st of July or after, anytime after that.
We do the 28th, Your Honor?
Yes. July 28th will be the next hearing of the pre-trial at 10 o'clock. Not guilty, please.
Yeah, it's Rich, not Raj.
And she'll need, well, let's see. I think she's still, we don't have a fingerprint card, so.
No, 6
Okay.
619.
Were you fingerprinted, ma'am, at the jail?
Yes, I was.
Okay, all right.
Do I need to still go there?
No.
Okay. Okay, for that. Anything else? We're good?
That's all.
Thank you, Your Honor.
You're welcome.
State of Ohio versus Christopher Faulner, Commissioner for CRB 25-335 ODAC, CRA 25-334.
All right, sir, you're Christopher Faulner.
Sir.
And you don't have a lawyer, right?
No, sir. I pled guilty to charges.
We had set this for a sentencing, and it looks like he was not here, and also was set for a pretrial. He's at ODP?
He's with our outpatient office. He informed me this morning that the reason he wasn't here was because he turned himself in on the warrant in Lawrence County, Kentucky, and was incarcerated.
Okay,
But he has been compliant with outpatient.
all right. And you're going to outpatient in Huntington, or?
Yes, sir.
In Huntington? Okay. Well, let's just go ahead and finish this up and do the sentencing. Looks like there's an A, B, and C case. And I'm a little confused on that. Okay, I guess we should read the affidavit to see why there's an A, B, and C. So this is an affidavit from Deputy Atkins dated June 6th of this year. I was dispatched to Walmart reference to an active theft in progress en route. Dispatched by the Walmart Loss Prevention reported the mail had exited the store, left in silver Mazda. Last seen heading toward Lowe's. When I arrived at Walmart, I did not initially observe the vehicle. I made contact with Walmart Loss Prevention, showed me surveillance footage, confirming the male suspect and his clothing left parking lot direction of Lowe's. I advised Walmart I would return later, tried to locate suspect located in Silver Mazda, unoccupied in the Lowe's parking lot. Lowe's personnel informed me the same male entered their store, was walking around selecting merchandise. Positioned my cruiser alongside of the lot to maintain visual surveillance, waiting to see if the suspect would attempt another theft. Deputy Pennington and I maintained phone contact with Lowe's staff and monitored the suspect. They advised the male had items in his possessions, but no longer had them. They informed us the male was exiting through the lumber department stores. Deputy Pennington and I approached to stop the male in the parking lot. He was walking towards the vehicle, advising he was under arrest for theft from Walmart. During search incident to the arrest, I recovered multiple stolen items concealed in his jacket, pants, confirmed belonging to both Lowe's and Walmart. He was identified as Charles Faulner. Gave him his Miranda rights, admitted to taking the items. Said he had a newborn baby at home. Total value of Lowe's items was $108.90. We searched his vehicle for stolen items. Walmart returned total value of merchandise stolen from them was $128.19. And then the C case was a trespassing. Yeah, it's a theft. It's also a theft. I think one is Lowe's, one's Walmart. That's what it should have. Yes. Lowe's was the A case, B was the Walmart case, C was trespassing, because apparently there had been a fire at Walmart. Okay, what do you have to say, Mr. Faulner?
Sir, I was guilty for what I did. I stole what I stole. I'm just trying to get it all taken care of.
So, and I had ordered you to go turn yourself in Lawrence County, Kentucky, and you did that. That's when you got.
Yes, sir. Yes, that's
What's
why.
going on with that
That's
case?
why I missed. That's why I missed the court. I go to court Wednesday
Okay.
for that.
Okay, I'm going to dismiss the extradition. That's the 25-334 that you reported there. To Kentucky. Yeah, you can say, I think it was
Lawrence County.
Lawrence, it was Lawrence County, Kentucky, that's right. Then on the charges here, on the theft, A case, I'll impose a $100 fine, court costs, 30 days in jail, and I'll suspend those days as long as you are compliant with treatment
Yes, sir. Thank you,
at
sir.
ODP. I will order you to do 5 days community service,
Yes, sir.
2 years of probation,
Yes, sir.
order you stay out of the Lowe's,
Okay.
and I'll set your next review hearing in August. Let's make it August 22nd. So OVP will give me a report then as to how you're continuing to do with your treatment. On the B case, which was the theft from Walmart, $100 fine. I won't charge extra cost on this since it all happened the same day.
Thank you.
30 days in jail suspended.
Thanks.
We'll order you to do community service at 30 hours, 2 years of level 4 probation, complete your treatment at ODP.
Yes, sir.
August 22nd will be your hearing date,
What time, sir?
9 a.m.
9 a.m.
And on the trespassing, I'll impose a $50 fine.
Thank you, sir.
And you're also ordered to stay out of Walmart.
Right, thank you.
Go see Mr. Major in the probation office. Continue with what you're doing at ODP.
Sure.
And that's the main thing. I want to see you get clean, stay clean, get a job, take care of you, have a baby.
Yes, sir.
Okay, that's going to be your #1 priority right now.
Yes, sir.
How old are you?
I'm 36, sir.
Okay. Fully grown
Yeah.
man, actually aging out of the NBA now. He would be old in the NBA. So time to grow up, start acting like a fully grown man.
All right.
See you on August 22nd for your
All right.
next hearing.
Thank you, sir.
Thank you, Your Honor.
State of Ohio versus Brittany Smith, case number TRD 25820, CRB 24171. Brittany Smith.
How are you?
I'm good, how are you?
Busy?
Yes.
Sure you're busy. Okay, I told you I would dismiss your no license case if you got reinstated. Did you able to get reinstated?
Yes.
Okay, you got your license with you or something showing?
I do have it, it's in the car,
Okay.
but I can get that.
All right, we need to see it. How are things going? You've been going to RRS, right?
Well, honestly, sir, I have not, due to the last couple weeks that I was going there in my pregnancy. They tried to tell me that I didn't screen, but I went and seen my counselor, and I was there like 5 weeks in a row, and she just didn't screen me. And then I had the baby and stuff, and I just felt like I was being done wrong, so I kind of just took it upon myself to not go back.
Okay.
But
You got 2 things to do then. I'm going to screen you here today,
Okay.
and I want to see your driver's license.
Okay, you got it.
Okay.
Thank you.
State of Ohio versus John Runyon, case number CRA 25349.
I am.
Sir, are you John Runyon?
Yes, sir.
Mr. Runyon, do I need to go over your rights with you? You were here when we explained rights of defendants?
No.
Or not? You have a right to remain silent. You don't have to say anything. You can choose to make statements that can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bond, and to make the state prove the charges beyond a reasonable doubt. You understand those things?
Yes, sir.
The charge against you is possession of cocaine. It's a felony of the 5th degree. Carries a maximum penalty of a year in jail, $2,500 fine. The state's alleging on January 17th of this year in Fayette Township, you knowingly were in possession of cocaine. You understand the charge?
I do.
You have money to hire a lawyer.
I don't.
You have a job.
Half and half.
What do you do?
Deal cards.
I didn't understand what you said.
I'm a card dealer.
Oh, car dealer. Okay. How much do you make in a month?
Depends on how much I work. I haven't been getting to work much.
Okay. I have to determine your gross annual income, so you gotta help me out here. Tell me something you make in a week, a month, a year, whatever, and I'll try to do the math and figure out what your gross annual income is.
$300 a week.
Okay, so that's $15,000 a year. You're eligible for the lawyer, and I'll appoint Mr. Smith to represent you. Mr. Mr. Arraignment has a felony possession of cocaine charge. What's the state's position on bond?
Your Honor, the state would not be opposed to an OR bond. We would like for Mr.
He actually posted a bond.
Okay, so we're okay with that continuing. We would like, as a condition of that he be assessed for treatment. I'd like to explain briefly about the fact that this was actually occurred on January 17th, and we just filed it in June, and we got results back already, and we had delayed it for some reason. I'm not exactly sure why, but that's the reason for the delay in getting it before the court.
Is there any other charges coming with this?
Don't know, but I don't think so. No, not that I'm aware of.
Okay. So the state's asking for, as a condition of bond, that you get an assessment for treatment. Is that something you're going to do?
I don't understand. I'm on some option. Yeah. It's just some option.
I don't know if you had any kind of, how do you pay for your medical visits? You have a medical card?
Medical.
Okay. He's got a medical card, Judge, in Ohio. Okay. You want to get this assessed? He's fine, Judge, if we could maybe find a provider that can assess it. Parkerville School. Front Street. He does, yes.
He can go to OBP, he's right in Parkerville.
Yes, that's fine.
You know where the OBP is?
Yes, sir.
Okay. All right, I'll make a condition of your bond that you go to OBP. Ms. Dement's here, so I want you to talk with her. She's from OBP. When would you like to come back, Mr. Smith?
Judge, I can do the 21st of July, the 28th of July.
21st is fine.
Is that fine?
July 21st. Be the next hearing, preliminary hearing at 10 o'clock. Mr. Runyon needs to check in with Ms. Dement from OBP before he leaves.
And I've prepared a time waiver for that.
State of Ohio versus John A. Barker, case number CRB 23115, TRC 23148, BNC, CRB 23116. Your Honor, I believe this is Mr. Smith and this case.
Case number 23194, 23115, 23116, and this is Mr. Smith's case. My record shows there was a pretrial that was not attended on April 21st of 23, so.
Yes, sir. I was in Maryland at the time. I was looking for my son. His mother went to prison in Maryland, and it was kind of an emergency. I had to go in.
Well, I'm going to direct you to talk with your attorney, and then let's recall and decide what we want to do.
I'll speak with him now,
It's been a
Judge.
warrant outstanding, so recall when you're ready.
Thank you, Judge.
State of Ohio versus Jason Allen Morrow, case number CRA 25330.
Sir, are you Jason Allen Morrow?
Yes, sir.
That's a copy of the charge you just been handed. It's a criminal mischief charge. It alleges that on May 27th of 2025, Union Township, without the right to do so, you moved, defaced, damaged, destroyed, or tampered with property of James Thomas Michaels. Criminal mischief is a first-degree misdemeanor. It's a maximum penalty of 6 months in jail, $1,000 fine. Do you understand the charge?
Yes, sir.
You understand your rights?
Yes, sir.
How do you plead to this charge?
No contest, Your Honor.
No contest means I'm not fighting it, I'm I'm not admitting I'm guilty, but I'm not fighting it either. And Judge, you think the state has enough evidence to convict me? I agree I can be found guilty without a problem whatsoever. So 99 out of 100 times it results in a guilty finding. Do you understand that?
Yes, I spoke with my therapist and my psychiatrist, and that was just, it's the best route to go.
Okay, well, that's a decision you have to make.
Yes, sir.
Okay. All right, does the state have any kind of report on this?
Yes, Your Honor. This is from Corporal Mullins of the Lawrence County Sheriff's Office. May 27, 2025, at approximately 2200 hours, so 10 in the evening, I was dispatched to 6 Private Drive 200, Chesapeake, Ohio, referencing a back glass of a vehicle being shot out. I arrived and made contact with Mary Jo Michaels, age 17, and her father, James Michaels. MM, that's the alleged victim, had been visiting her boyfriend, David Colton Lewis, age 16, at 6 Private Drive 200, where Mr. Lewis stays with friends. As MM was leaving the residence, driving southbound in front of 275 Township Road 287 North, when the back glass of her vehicle shattered, MM turned around and drove back to the residence her boyfriend was staying at. MM advised that she did see a male subject standing on the front porch at 275 Township Road 287 North, who was later identified as Jason Morrow. The subject at that address, Braxton Adams, and DL, that's the boyfriend, I think, walked back down to the residence and spoke with Mr. Morrow, who they advised admitted to shooting the back glass out of MM's vehicle, and that the next time it would be a 9mm. Mr. Adams advised that Mr. Morrow had told him that MM was driving too fast. Mr. Adams asked to see the camera footage of the incident. According to Mr. Adams, Morrow hit the fast forward button to make it look as if MM was driving faster. When Adams left to get his father, Mr. Morrow left the residence fleeing on foot. I took written statements from Mr. Adams, MM, and DL. In addition, I photographed the vehicle, a 2004 Saturn Ion 4-door, golden color, bearing Ohio tag JCS 1011. The rear glass in the vehicle was shattered. I spoke to the owner of the vehicle and MM's father, James Michaels. Mr. Michaels had given me permission to speak with his daughter, as had the mother of DL, Rebecca Lewis, who also gave me permission over the phone. I also had Mr. Michaels sign a request for victims' rights packet, which he was given a copy. I next spoke with the resident at 274 Township Road 287 North, Angela McCoy. Ms. McCoy advised that she was in the shower when this incident had occurred, but that she had gotten out of the shower when she heard a lot of yelling going on. Ms. McCoy did advise that her son, Justin McCoy, age 13, JM advised that he had been inside the residence with Jason Morrow, and then when the car went flying by, Morrow had stood up, went outside, and shot at the car with a BB gun, hitting the back window. JM further stated that Mr. Morrow had intended to hit the side of the car and not the back glass when he shot the BB gun at the vehicle. JM stated that Jason Morrow left the residence right after Braxton Adams and walked away. Both Ms. McCoy and JM advised that Mr. Morrow did not come back and that they were unsure where he went. But Ms. McCoy advised that he does stay at her residence. Body camera footage of this incident was attached to the report. This is in violation of 2909.07, criminal misdemeanor of first degree.
Mr. Morrow, do you have any explanation or statement you want to make in response?
There's a lot there, Your Honor. It was accidentally shot out. I will admit, I've already pled no contest to it. It was accidentally shot out. I offered to pay for half upon showing them the video that they're accusing me of, fast forwarding through. I've got cameras on both ends of the house. And, it was just an accidental incident.
It wasn't an accident, you deliberately shot at the car, so
no,
you can say that's an accident.
I didn't aim at it or anything like that. It wasn't an aimed intent.
You may not have intended to break out the
Right.
window, but
But
if
it
it had
happened.
consequences, you know, would that always happen? No, but I think it's not out of the realm.
It's not out of the realm, no, sir.
When you shoot at a car with a BB gun, you could break the glass in that car, so. Mr. Hill, what's the state's position on it?
Well, the state would ask for the court to make a finding of guilty and delay sentencing and let us get restitution information and a recommendation as to what the sentence should be. And Mr. Morrow's already said something about going to treatment or something. I'm not exactly sure what he said, but.
Well, as I
Yes, sir, Your Honor.
you're doing some mental health treatment?
Yes, sir.
Okay.
We'd like that to be a component when the time comes.
All right, so what I'm going to do, I'm going to delay sentencing, which is what I have to do now. The Supreme Court says I can't make a restitution order later. I have to do it at the time that I sentence you. And I don't know what the restitution should be. I need to hear from the folks that own the vehicle. So I'll give the prosecutor a chance to get them in here, and we'll hear what they have to say about the cost to repair the vehicle. So I'm going to delay your sentencing. What kind of time frame do you think you need to get them into court? It's probably going to be after, let's say, the 25th or after.
I think that should be adequate. Your Honor, it's possible that there is a restitution amount in the court's file because we have got, all right, well, we got information that they were going to bring it to the court, so
There's nothing in the file. I'm going to set it for the 28th, because I'm not going to be here the 25th. So the 28th of July will be the sentencing hearing. So that's 3 weeks from today for sentencing. And that'll be at 10 o'clock on July 28th. Mr. Morrow can sign a $1,000 signature bond. And he will need to be fingerprinted. So make that a part of his bond. Be back here July 28th for a sentencing hearing.
Thank you, Your Honor.
You're welcome. During the pretrial docket, so lawyers who want their cases heard need to be in the courtroom.
State of Ohio versus James Townsend, case number CRB 25204.
Mr. McDonald's case set for pretrial.
Thank you, Judge.
Pre-trial, if you have a court case, you need to be in the courtroom. If you're not in the courtroom, you'll go to the docket.
All right.
What's your name?
I need to engage Townsend's file. Is Erica? Erica Townsend? Come over here. Your Honor, I don't know if the court's been supplied a copy of the letter from the counselor. Mr. and Mrs. Townsend have been doing marriage counseling.
Thank you. Okay, what's the state's position on going forward?
It's my understanding that they have another meeting scheduled for just a few days from now.
Wednesday.
Maybe some more after that. And she reports that things are going very well. And I can tell just by the facial expression that she's pleased with the progress. So we're happy about that, but we're not ready to say that it's fixed at this point. We wanted to continue on. We'd like to come back again in maybe a couple months, if that's okay, and bring another report. And we need a time waiver in order to do that, but we'd be happy if they got another good report. We have represented previously that we would be willing to discuss a dismissal with payment of court costs if they're successful with the counseling, and it looks like they're well on their way to that.
Okay, sometime in September?
Sure. That would work for us, Your Honor.
September 12th?
That works for me, Judge.
All right, next hearing will be September 12th at 10 o'clock for pre-trial.
State of Ohio versus Melissa Levens, case number CRB 25261.
It's Mr. Holt's case set for pre-trial.
Yes, Your Honor, I filed a motion. I actually actively represent the spouse of the alleged victim in this matter.
Okay. This was an appointed case?
Yes.
All right, ma'am, any objection to him resigning then?
No, sir.
So I'll allow that, and then you're asking for another attorney to be assigned to you?
Yes, sir.
And just to check, what's your circumstances with regard to work? Are you working or at all?
I work for my mom, so I don't have a job.
You take care of her?
Not at the time, no, but I'm getting ready to check into a CNA class for a week. So.
Currently, you have?
Currently, no, I am not, sir.
Okay. Mr. Steyer, I'll appoint you to take care of her. Melissa Clutters.
Yes.
Is the name, it's a menacing charge. I'm setting pre-trials. I understand. Probably the 25th or after.
I'm available the 28th or the 1st of August. Does Monday or Friday matter to you?
It does not.
Okay.
July 28th.
Thank you.
July 28th will be the next hearing for pre-trial.
10 o'clock.
So I'm going to ask you just to step into the lobby here and wait for me to get your file and come out and speak to you. Thank you.
State of Ohio versus Michael J. McKenzie.
Thank you.
Case number CRB 25337.
This is Mr. Holt's case, pre-trial. Michael McKenzie.
Is Bonnie here?
Mom's here. Mom's here.
Is Bonnie here?
She needs this.
She's coming up.
Okay.
Yeah, I'll have to call that victim. I'm not going to turn it happy. They go and see something. I have to call and see something.
not sure.
May we approach, Your Honor?
Yes. All right, based on the state's further investigation, they're willing to dismiss the charges, so case is dismissed.
Madam Clerk. Thank you, Your
State of Ohio versus Emily Nagy, case number TRC 251308 A and B.
Mr. McCown's case.
Yes, Your Honor.
For pretrial.
Thank you, Your Honor. Your Honor, after discussion with court counsel in pretrial, it's my understanding that due to the significant evidentiary issues, the state is willing to dismiss the charges upon Ms. Nagy's completion of a dip school in this matter and removal of the window tent. We've also prepared a stay of the ALS that's agreed upon.
You have an entry on that?
I didn't have it.
Yes.
August, I think it's 15th, for her to report back and take care of that. I think the court wanted to keep it on the docket. We wanted the offer on the record, but I think the court wanted her to perform that dip before it dismissed. Is that correct?
So when do you want to come back?
August 15th, if we could, Your Honor, and then if she's done prior to that, then...
You can move it up if you would.
Yeah.
August 15th will be the next hearing scheduled, 10 o'clock for pretrial. The entries in the file, you might want to follow up getting it.
Thank you, Your Honor.
D&D.
Yep, thank you, Your Honor.
Yeah.
State of Ohio versus Donald Donahue, case number CRA 25170, CRA 25175.
Mr. Smith's case. I'll make it pretrial.
Okay. Yeah, you're fine. Just. Judge, I did speak with Mr. Hill, and I've also got some documentation from my client. At this time, my client is prepared to enter a guilty plea to the theft charge. I was doing some research on that, so we're going to go ahead and do that today. And then I do have letters from Graceway Counseling, one dated June 26th, one dated July 3rd, if I may approach and provide this to the court. Get these judges to keep.
Yes. Okay, so the theft is the 25170, case number March of this year?
Yes, Judge.
Okay. All right, do you agree, Mr. Donahue, you're changing your plea on that charge? Anything you want to tell me about it?
I don't know.
No? Take any position on the sentencing?
No, Your Honor. The other charge, of course, we wanted to remain pending.
Yes, we're going to track the other one.
All right, on the theft offense, I'll impose a $100 fine, court costs, 10 days in jail suspended. Under the circumstance, I'm going to do away with the community service requirement. Will require him not allowed to go into Walmart, 2 years of probation. And I'll set it, come back in another couple of months on the other matter, just to monitor his.
We could, Judge.
Okay. So sometime in September.
Yes, sir.
I'll set the review on the theft in for September 12th. Are you available?
Yeah, that's Friday. I'm here anyway, Judge.
Okay. And then on the 25-175, I'll set it for another hearing that same day, September 12th, to continue with his counsel that he's been showing to the court. Okay. And you'll need to go check in with Mr. Major on this probation on that.
Yes, sir.
That's our next court date. I'm going to leave here to go to this office to you after.
State of Ohio versus Alexis Neese, case number CRA 25403, CRD 25365, CRD 22766, CRD 211431, CRD 183892, TRC 183327, TRC 191170, A, B, and C. There are 2 new charges.
Charges.
What he just said.
Yes, sir, from
You're expecting?
June 18th.
All right,
But
Mr.
that's why I
Smith,
was
there's
in
2 new charges Ms. East has not been arraigned on that we need to do.
Yes, sir.
25-365 is a theft offense from Walmart, June the 11th of 2024. And then 25-403 is a possession of a fentanyl-related compound. It's dated June, the alleged incident was June the 11th, 2025. I'm wondering, I'm going to say, one of these has a long date. I'm going to assume it's the theft, but it's saying June 11th, 2024. The drug charge says June 11th, 2025.
I would say that the 2024 is an error, and we'd ask to amend that to 2025.
No objection, Judge, to the amendment.
Okay. The amendment 2025 allegation on the theft. So, Mayor, not guilty on the theft offense. I'll appoint Mr. Smith on the both charges. She's at the counseling center now.
She is.
And how's that going?
She's doing well, Your Honor.
I graduated 2-5, and I'm in the step-down program that they have, and I'm getting ready to go to transitional.
Okay, I do have a report. Well, the only thing that concerns me is she was at the counseling center apparently when this allegedly happened. Is that right?
No. This is from a year ago.
Maybe it was 2024.
It was, I admit to it, I mean, I'm not gonna sit here and lie about it.
Yeah, it was 2024.
Right.
The affidavit was 2024, so I'm in the one that says 2025 to 2024. They both are 2024. June 11, 2024, the incident date. Okay, so she should stay, obviously, in counseling. We'll continue to monitor these and keep them here.
Is she one of those?
Come back in another month.
That'd be fine, Judge. I'm here the 4th or 8th of August.
August 8th. August 8th will be her next hearing on all her cases.
Thank you.
Yeah, but it's a theft charge. Now that. Maybe that came along with that happened. I don't know. I'll have to look at it.
State of Ohio versus Heather M. Webb, case number CRA 2561.
Yeah, at OVP.
Mr. Smith's case.
Yes.
She's at OVP inpatient.
Yes.
Yes, sir.
So this would be 30-day program.
Yes, we just got her from the jail on Saturday.
Okay.
So Saturday.
That would have been last.
4th.
Yeah.
July 28th.
Yes, Judge, I can do that.
So still be at OVP then?
Yes.
July 28th is the next hearing.
And then we'll need a time limit for that too.
No, yeah, we'll do time for it. That's fine. Just print them out.
State of Ohio versus Adria Price, case number CRB 25693, CRB 2557.
Approach your honor on this one.
Yes.
I made my appointment, but they have me a lot later. They said it's August the 8th, I think.
Right, next hearing will be July 21st for pretrial and working with Pat and Southern Ohio Forensics.
They discharged her.
I'll talk to you about it then. All right. That's good news.
State of Ohio versus Trenton R. Moore, case number CRD 25-2. Trenton Moore.
We think it's ready. I'm not anticipating that.
So is this a completion?
Yes.
Yes.
minutes where if there's no further problems, completion and payment of costs would be dismissed.
That's correct, Your Honor, so I think we've reached that point.
And the costs we pay.
They were dismissed to pay the court costs.
Yeah.
Have they been paid?
No, I haven't paid
You paid today. How much are they, Judge?
150.
Yeah.
Probably.
They need to be totally done. He can pay that today, Judge.
This is,
That way, you don't have to come back, just pay it. One fee, you can pay that today, Judge.
All right, see the clerk, case will be dismissed on payment of costs.
Right, when you leave. You're done.
Thank you, Your Honor.
Take care. See you.
State of Ohio versus Cheryl A. Russell, case number CRB 25216, A&B.
Roger Smith's case set for pre-trial.
Your Honor, if it please the court, this is a case that I guess would be best described as a road rage type situation. There was another lady involved with this, Carrie Tucker, and she was charged also with reckless operation and disorderly conduct. And we dismissed that charge previously when it came up for trial. The reason being that it would be almost impossible for us to prove the case against either one of them. They were the only ones that witnessed what happened. And so that's what we would do with this charge today. We would enter a dismissal to that.
Case will be dismissed.
No objection, Judge. Thanks.
State of Ohio versus Michelle Apin. Michelle Apin, case number CRB 2595, CRB 2596. Regarding this is set for preliminary hearing, scheduled to be in another court.
Thank you, Judge. I appreciate it. You're wrong. She is a Bethesda judge, right? Everything goes well. Okay.
Case number 2595. Good report.
She's doing really well.
Okay. But not finished, right?
No.
And she had 2596. Yeah, I see 2596. Was a Walmart theft.
She was sentenced on that.
Yes.
I thought she...
All right, she'll need to do, she's ordered to complete treatment and do community service.
How many hours of community service does she?
30 hours.
30?
Can she start working on that?
Yes.
Okay. Be looking for that the next time frame. When is she gonna finish it? Because you have a projection.
I'm at 130 days.
She's got about 50 more days to go for, so a little shy of 2 months.
Okay.
And I think
Come
our,
back about that time frame, see where things are, then that would be September, 1st of September sometime.
Let's see, Judge, yes. So Judge Howard's calling up. I believe the 12th, Judge.
September 12th will be the next hearing.
Thank you, Your Honor.
Thank
You're
you.
welcome.
State of Ohio versus Daniel Lucas, case number CRA 25389, TRC 251456, A, B, C, and D.
Good morning, Your Honor.
He's inpatient at ODP.
There's going to be a waiver to the grand jury on this case. We'd ask his bond be transferred.
Okay.
They had skipped, we will nolly that one to the grand jury.
Approach, Your Honor.
Yes. All right, so 25389 is going to the grand jury. 251456 was the same, A case was the same, the other was B, C, and D. Do you want to acknowledge those?
Yes, Your Honor.
So the B, C, and D,
I'm sorry, I just took over from Missy. Is that waived to the grand jury on the 25389?
yes. Then on TRC 251456, the A case, I think, was already been nollied. Yeah, there was a nollie on that because it was refiled.
Yes.
But the B, C, and D are misdemeanors that go with the felony, so they're nollied to the grand jury. And that's a no driver's license, turn signal, and hit skip.
State of Ohio versus Casey Lynn Levens, Case number CRA 24487, CRB 24488, A and B.
Mr. Smith's case, preliminary hearing. Big report on OBP. How's the state want to proceed?
Well, we would like to see her follow through and complete her treatment. It says she continues making progress, so that's good news. We'd like to see her follow through to completion.
Come back in 30 days, Judge. I'm here August 4th or August 8th or August 15th.
Nothing in July?
I'm sorry, that was August.
August.
Yeah, I think I'm like that.
You're right.
4, 8, or 15.
Let's do the 15th. August 15th. Preliminary hearing.
Thank you, Your Honor.
Thank you.
State of Ohio versus Tina M. Wells, case number CRA 24604.
Report's good. Hometown. And she's at Mahasman
It's
We're okay with her continuing on to complete her treatment. Sounds like she's made great strides.
Can I say something, Your Honor?
Yes, ma'am.
I have actually completed treatment, but I've went, I'm paying rent in one of their independent living places. So,
You're looking for your own place now, so I...
yes,
Right.
that's where I'm at.
They're helping you?
Yeah, they're helping me as far as, I want Ironton, but there's no apartment, so I'm staying in an independent house that they've got. Yes.
Okay. Well, maybe we can wrap things up next time in September.
Yes, Your Honor. Possibly. As long as I pay off all my fines, I'm working on them.
Okay.
I'm chipping away.
September, Judge, the 5th or 12th.
September 12th will be the next one.
It's hard to find the place.
Oh, sure.
Thank you, Your Honor.
You're welcome.
Thank you, Your Honor.
State of Ohio recalls Brittany Smith, case number CRB 25820, CRB 24171.
Okay, good screen. Screen is good. And you got your license?
I do. This big one, so, what is it? I have this big one, if this one doesn't work.
All right, I'm going to dismiss, I already told her I would dismiss 25, 820, she got stated. And then the other will just be on reviews. You still have months.
Yeah, I'm working on it. I've paid $70 so far.
I'll set your next hearing toward the end of August. August 22nd. 9 o'clock, August 22nd.
Okay.
I want you to continue with your counseling.
We good?
Yes.
State of Ohio versus Michael Davis, case number CRB 25362, A and B, CRB 24467, CRB 24649, A and B, CRB 24215.
Your Honor, I believe Mr. Davis is there on the video. He contacted me this morning. He is in Ironton and was able to get a ride down here. Rather than not appearing at all, I gave him the Zoom information and asked him to log on.
Okay, it looks like there is an amended complaint, or
I wasn't aware that it had been amended, Your Honor.
you wish to accept.
I'll accept service.
It's 25362A.
I would waive reading, enter a not guilty plea on Mr. Davis's behalf, Your Honor.
Will be appointed to represent him. Where can we go from here, Mr. Hill?
Your Honor, he's got a very serious charge pending, this sexual imposition charge, which we intend to pursue. He also has a probation violation pending, and he has a number of days in jail that are could potentially be imposed. So he's got quite a lot going on, and if we need to set him for a trial, we can go ahead and do that. If he wants to file for discovery, we can do that, he can do that, and we can come back again.
I would at least like to file for discovery with the new charge and then come back one more time for a pre-trial. At this point, Mr. Davis had also raised the question of being able to return home. I don't know if the alleged victim is still residing in his home or not.
I still live in that home.
home, I pay bills in that home. I'm still in that home. If he would like to come get his stuff, he could either contact my mom like he's been trying to and set up a date for that while I'm at work, or have a cop escort him.
I would advise him, if he can contact his wife, I would advise him to do that and then make arrangements to pick up some belongings if he needs to.
When you want to come back to the
You said you were setting dates. We set for August 1st, Your Honor. Well, hang on just a second, sir.
Okay, I'll set the next hearing for August the 1st for a pre-trial on everything before the court.
Thank you. Well, before you ask anything, I'm going to caution you, as always, you're on the records. If you say something that is incriminating, it can be used against you.
I understand. I just want to say, I'm still married to Randy, and I mean, like this, I can't call me my marriage, you know what I mean? Like, I would like to be with my wife,
Well, unfortunately, as I just explained to you earlier, if she's a resident in the home, when by she I mean the alleged victim is a resident in the home and there's a protective order in place, you aren't allowed to be there. If your wife wants to join you where you are, that's her prerogative, but she's allowed to be there, you're not. So that's where things are at the moment.
Well, then what is this new charge?
It's basically the same allegations with just a different difference in how it's charged. I'll discuss that with you off the record. That's not something we need to be talking about in the courtroom.
Who filed that charge?
The state of Ohio.
That's enough. You can talk to Mr. Steyer. You're not going to hold up 50 people in the courtroom while you have this conversation with Mr. Steyer. Next hearing is on August 1st, 10 o'clock.
Thank you. I'll talk to you later on, Michael. I'll talk to you later, Michael.
State of Ohio versus Otis Sexton, case number CRV 25397, A and B.
All right, this is Mr. Stratton's case. I thought he was going to be here today.
It's my understanding he had a jury trial in Scioto County today.
Okay.
Because I had something in Scioto County that he's on, and they were talking about he and the prosecutor were going to be tied up for the first part of the week.
All right, Mr. Sexton, we'll have to continue your case then.
Your Honor, if I could say something.
Well, it's not a good idea without your lawyer being here. You understand that? What you say is on the record, it can be
Right,
used against
yes,
you?
yes. My cousin Rush Onions is here on my defense, and he's not want to pursue this complaints.
Okay, well, he can talk to the prosecutor.
Mr. Runyon?
Yeah.
That's what caused it. All right. So Mr. Runyon, the alleged victim, is here. He urges me to dismiss the charges. The allegations are that they were both intoxicated and got into it, and I thought that what Mr. Sexton is alleged to have done was pretty serious. He's been in some stuff before that was pretty serious, but Mr. Runyon doesn't want me to pursue the charge. They live together, and he thinks they can get along. I told him they need to lay off the booze or whatever if they're going to live together, not kill each other.
Yes.
So this charge of the aggravated menacing with Mr. Runyon as the victim, we're okay with dismissing that because he's urged me to do so, and he's a full-grown adult. However, we do think that Mr. Sexton was disorderly, and he ought to plead guilty to that, a minor misdemeanor. We'd ask for a $50 fine and court costs if he did that.
Yes, sir.
What do you say?
Guilty.
Okay, you're agreeable? All right, I'll dismiss the more serious charge, the A case, which is the menacing at the request of Mr. Runyon. You're pleading guilty to the B case, which is disorderly conduct. I'll impose a $50 fine, court cost. Can you pay that, or you need time to pay it?
I'm gonna need time.
Okay. 2 years of level 5 probation with a review hearing on January 12th of next year, 9 a.m. Go check in with Mr. Major, get your paperwork. If you pay it before January 12th, you don't have to come for a review. If you haven't paid it by then, you gotta show up. If you don't show up, you'll get a warrant.
How much is the fine?
$50 plus court costs.
Plus court cost.
See Mr. Major in the probation office.
January 12th?
January 12th.
Thank you.
You're welcome.
State of Ohio versus Sean Paul Burns, Jr., case number CRB 25117.
This is Mr. Morgan's case, pre-trial.
How are you doing?
I'm trying to get mine saved up so I can get the place in there. So I can complete the program.
Okay.
That's all I need. It's financial.
Good report.
Judge is trying to save up money to find a place to live, and then he will be finished with his treatment program.
Okay. What's the state looking for on this case?
Well, we want him to complete his treatment, which sounds like he's doing a good job right
And the
now.
victim's his father, it looks like.
Yes, and his father wanted to get the treatment. Yeah, and his father just wants him to be successful in treatment. And we understand too that he's got some medical struggles that kind of play into this as well. We're okay with him continuing in that treatment. We'll check his progress towards a dismissal in the future if he's successful.
Do you have a projected finish date?
At the moment, right now, it's financial. I'm in a situation I have to, I gotta find another job. So, and save up the money to get a place. And that's what my case management and they're helping me with. So,
Probably at least a couple months.
Probably maybe a few months. I might be there there a little longer than I was expecting. So, but it could be a couple months. It just depends on how much the job is paying me. And
Let's look at mid-September, Mr. Morford, what's your schedule?
I'm pretty much free that month, Your Honor.
September 15th?
That's good.
September 15th. trial, 10 o'clock.
Okay. Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
State of Ohio versus Andrew Smith, case number CRA 24773, CRB 24774, CRB 22430. Your Honor, please hold on the scene.
Amber Smith is Mr. Morrow's case.
I also really important that
You're still recovering from it?
Yes, sir.
When's your expected completion?
5 months. I'm 7 months free on Wednesday, so not just 12 months, I did for 7 months. Hopefully I'll be done by September, December, on that area. September, October. I'm not sure. But it's doing well.
Okay, so go to that same date, September 15th.
Yes, Judge.
Okay, continuing your treatment, we'll see you on September 15th. You can appear by telephone once again.
Okay, what time?
10 o'clock.
Alrighty, thank you.
You're welcome.
Have a good day.
State of Ohio versus Jacqueline Chin, case number CRB 25317, CRD 151164, CRD 15971.
Walker's case, pretrial. She's also being monitored through common pleas.
Yes, Your Honor.
Screen and report are good. We have some more cases that she has fines on, and in this case, it's pending. It's a qualification. you representing your town police also, or who's your lawyer in town?
Chris Lauder.
Okay. Where is that going? Is it set for trial?
Got a pretrial on, I believe, August the 8th,
Okay.
and a trial on October 6th.
What sort of charge is that?
Involuntary manslaughter and corrupting another with drugs, trafficking in fentanyl.
I think that's just 2 counts.
2 counts of that, so pretty serious stuff.
Okay. All right, well, let's come back in September and see where things are headed.
Yes.
That's September 15th day?
Yes, sir.
September 15th. Pre-trial on all 4 cases.
All right, caller, you may.
Okay, start some of the jail hearings now.
State of Ohio versus Jamie A. Baker, case number CRB 25402.
Oh, yeah, that's
Sir, are you Jamie Allen Baker? Yes. Mr. Baker, you have the right to remain silent. You don't have to say anything. If you choose to make statements, they can be used against you. You have the right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove these charges beyond a reasonable doubt. You understand those things?
Can I hear again, please?
You have the right to remain silent. You have the right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove any charge beyond a reasonable doubt. Those are your rights. All right, so you're nodding your head yes. I assume that means you understand this. You're charged with aggravated menacing. The state's alleging on July the 6th in Fayette Township, you knowingly caused Donald Starr to believe you were going to cause serious physical harm to him or his property. That's aggravated menacing. Maximum penalty for that is 6 months in jail and a $1,000 fine. You understand that charge?
Yeah. So you know the stuff he put me through the last 8 years? I ain't saying that didn't happen, but after everything and what I caught him doing the other day, by all means, like, can he be here to, like,
yes,
never say, because I want him here in person so I can ask him in front of everybody the same questions.
All right, I'm going to enter a not guilty plea for you. Then. And Mr. Morford, I'll appoint you to represent Mr. Baker. What's the state's position on bond for Mr. Baker?
Your Honor, the allegation is he threatened this guy with a hammer, raised it above his head, and threatened to strike him with it. He's also basically admitted that on the record, and I'm a little concerned about maybe his mental well-being. So we would like for there to be a $5,000 cash or surety bond.
Set bond of $5,000.
And a protection order, Your Honor.
With the protection order stay away from Mr. Starr. Set,
I've been trying to stay away from Mr. Starr. He won't leave me alone.
I'll set the next hearing. July 14th. 1 week from today. 10 o'clock.
Yeah.
14th.
14th.
A week from today.
State of Ohio versus Stanley D. Bennett, case number CRA 25342, CRA 25343, CRA 2646.
Could you wait for a second, Bill? Can you wait, sir? Your Honor, Mr. Bennett has some charges here. We've been waiting on it. I'll order to be left from Common Pleas Court. Mr. Morford is his attorney in Common Pleas Court, and they are set for a community control sanctions trial on Friday. Oh, I'm sorry, on Wednesday. Okay. So there's really nothing we can do here until that matter is at least gets to a point where there's going to be a bond, if not a release of the order.
So there will actually be an evidentiary hearing?
I don't think, well, Mr. Morford is better able to speak to that than I will.
You think there will be an evidentiary hearing on Wednesday?
Yes, I do. I did check for evidentiary hearing. We've already had the arraignment on the TV.
Okay.
So it will be determined, as far as I know, on Wednesday.
So they're not willing to let him go to treatment then, at this point?
Not at this point, yet. They're talking time. He has 11 months and change over his head.
Well, he's got 2 felonies pending here. One of them is the 25-342 aggravated possession. It's an F3. And then he's got a 2020 felony possession charge also pending. And
does it make sense maybe they just all need to go to grand jury?
That's my thought. Seems like, how if they would want the charges to go there and be considered along with the probation violation or not, that would be, I guess, the question.
Well, it would seem to me, are they even aware that he's got these? That would seem relevant in the scheme of things. Are they aware that he's got these charges? I mean, this just happened June 7th.
Yeah, I told Val everything we were saying about running the jail.
In that case, then, Your Honor, it might be worth our while to, for the state of submitting all of these, and Mr. Morford to discuss the possibility of building information.
Makes sense to me,
Yeah.
And he's still got, he's got a felony and an OVI, it looks like. He pled guilty, it looks to me like on the OVI, never got sentenced though, because he was going to go.
Is this something that's going, where the felony is going to grand jury?
This was back in 2020.
I would ask them to withdraw the plea of guilty on the OVI and allow us to go to grand jury as well.
That's an old,
Yeah.
we would oppose that.
It's possession, he still has pending felony possession of drugs from back then. He was never sentenced on the OVI. Yeah, he pled guilty November 21st of 2022, and then he had another hearing. The way we were doing then is letting him continue with treatment. Came back on December 9th, 2022, wasn't here. And then apparently he was back on January the 6th of 23, January 20 to 23, failed to appear. And then he was out of pocket until these new charges came up to 25. So a couple of years. So what's the state's pleasure on that?
Well, we intend for the 2025 possession charge, and I think the other one's 2020. I don't have that in my notes. For those to go to the grand jury, we prefer a waiver, but we would nolly them.
Well, I mean, a waiver's fine, but we would, again, is the, let me just clarify, I'm sorry, is the OVI and does the possession arise out of the OVI, Scott? Or are these separate incidents?
Same day.
Oh, it is? Okay. So that's in 22, so that must mean that there's even another possession charge.
The one I have is in 2020, and I've got the 2025. You think there's another one in 2020?
No, what year was the OVI? I don't have that.
2020.
Oh, okay.
So if it arose out of the same incident, I think it should all go to the grand jury. So I would ask, but obviously if it's guilty, I would ask to withdraw the plea allowed within the grand jury.
And we would be opposed to that. Understanding Mr. Steyer's feeling about that, I'll tell you what we'll do. We won't take the 2020 possession. We'll nolly it. We'll just take the 20.
Right, well that's also a problem as well.
We'll just take the 2025 possession charge.
And we would waive the 2025 possession charge to the grand jury. We'll execute a waiver. In terms of sentencing, he has been in jail now for about a month. I don't know if, I recognize there's still issues of driver's license suspension and fine, but if this could stand as a jail time, he's put on the OVI. I don't know what offense number it is or anything of that nature.
Well, let's deal with the 25 first. So you've got 25-343, which was possession of drug paraphernalia. Do you want that knowledge to the grand jury? It's a misdemeanor, along with the felony.
On the 2025? Yes.
He had a traffic, which might be your probable cause. It's the same day, June 7th, 2025.
Yes, Your Honor.
25, 13, 19, A, B, and C.
That was for denied. I just got confused, I gave you the.
No, this is the one he's waiving. 25 case number. On the CRB, I'm sorry. I got you. I saw 25 now. No, it's okay.
The traffic charges are driving without a license, expired tags. And it looks like there's a C case somewhere. Is there a 25-13-19C case? Okay, A is driving under suspension. B is fictitious registration. C is a registration violation. So I think that was not having a sticker.
I'm good.
So all those are knowledge to the grand jury, those traffic charges, as is 25-343, which is possession of drug paraphernalia.
And Your Honor, I have had him execute a waiver preliminary on 25 CRA 342.
Okay. Okay, and I'll accept that. So that whole file is going to the common police court.
What about the any cases, Your Honor, are they?
That's what I'm going to deal with now. So we're still left, Mr. Bennett, having cases from 2020. One is an OVI, which he purportedly entered a guilty plea to some time ago, but was never sentenced on. He was supposed to be going to treatment on felony possession charges, and that got waylaid. 2646 is possession of drugs, methamphetamine, F5. And the misdemeanors are traffic. TRC 2015-22 A and B, OVI with a refusal and a prior, but it was in 01, so it was outside the look back. Well, I don't know. Is it 20 years with the refusal? What's the
10-year look back. No, I'm sorry, it is a prior in 20 years. So it would still be a first offense with a refusal and a prior in 20.
Okay, so that's the OVI, and there was also a driving under suspension. And they're the same dates as the possession charge. So.
And my understanding is the state's going to move the Nolly possession charge?
We nollied that possession charge, yes,
Okay.
outright.
So Nolly 2646. And then sentence him on, he's already entered a plea. My notes were as to the OVI. What's the state's position on sentencing for that? That's 2015-22A.
Well, he's been in jail a few days, so I suppose that would count for something.
Does common police have a holder on him though?
I assume.
You don't want him to get out, do you?
No. Well,
I believe it does, that's why we haven't been able to get into treatment. We were attempting to get him out to treatment on the other cases, so that's why he's still in jail, so it's not feasible.
okay, he had a common police holder on June the 20th, so I don't know if it still is there or not. Who's his lawyer in?
Mr. Morford.
Mr. Morford is right here.
All right, so what's going on there?
We have a PB trial this Wednesday.
All right. Well, he's still got the holder.
So I would say he's still under the holder of June 20th.
I think it will be safe to just turn it over to common police court.
All right, so anything you want to say, Mr. Bennett? No. So on the OVI, I'll impose a $500 fine where you pay the court costs. At this point, I guess it makes any difference if it's going to be expired. But a 2-year license suspension. No community service, just keep it simple, no dip school. And how many days have you been in jail?
I think the 7th. June the 7th.
Okay, so I'll give him 30 days in jail. Credit for time served.
Thank you, Your Honor.
Now, set a review hearing on this for January 12th of next year. 9 o'clock. Dismissal.
And if he is incarcerated on those cases, it will probably go to jail time, so he should be able to come in for the review if he's incarcerated. I believe he has in that, he's dealing with that 5, which is not prison element.
State of Ohio versus 6 Lee Sue Bittler. Case number CRA 25359, CRB 25360.
Is this Mr. Smith's case?
He's in the city.
I didn't know she had vacated the facility.
She did and got,
Yeah, I see that.
We'd be willing to take her back, she just needs a monitor.
you're still gonna have a monitor. Well, how about one of the horsemen? Mr. Tarvin, you wanna talk with her? Do you have any female vet? It's a county person anyway. Sure. Okay, we'll call you back up after you get evaluated.
Thank you, Your Honor.
State of Ohio versus John P. Blair. Case number CRA 25401.
It's an F3.
Oh, okay.
Ireland.
He was in,
Yeah. All right, sir, you're John P. Blair.
Yes, sir, I am.
You have a new charge of aggravated possession of drugs, F3, which I've delivered to Mr. Smith, who's been your lawyer in other cases, and I'm going to appoint him to represent you on this case. And you accept service and waiver reading?
Yes, sir.
So the issue is going to be bond and what? He apparently has other cases in common.
Judge Ballard, I'm assuming there's a whole lot of common pleas because he's not showing up pre-trial. We actually are on the docket for this Wednesday for Judge Ballard, not the status.
If I can just say one thing, I tried to do, I went to many reasons and put in an outpatient, my insurance took the day for it. And then I got hurt, and then I tried to put myself in cardinal rehab, unfortunately. And the only way I think I can do rehab at all, to have a chance to do rehab, being honest with the court, is to be placed on an ankle monitor. Because I don't want 7 years in prison.
We'll raise that to Judge Ballard because you're going to leave with you.
I heard you agree to it.
So I think under the circumstances with Judge Ballard having his other case, maybe it makes sense here just to give him an OR bond. That way Judge Ballard can do whatever he wants to with it. Just won't hold him up.
I think that sounds reasonable.
So, and he does have a holder for common pleas, I take it. I'll set it at 2,000 OR. Appoint you, Mr. Smith, to represent him. Do you want to agree to let it go on to common pleas? Sounds like it needs to join up with the other case.
That's probably even a better idea, have him waive.
Yeah, I like to be tried for representing once if I could.
Yeah.
Because that 5 one, I was, for the possession of 1 gram, I was going to ask you to test this the other. Sorry, I'm just trying to be honest.
Oh, no, we're going to just talk. We're just trying to figure out.
You want to have him waive today?
Well, won't have to sit in court for you, or, you know, I would.
You still got to see the judgment.
I know that, I'm saying if I would go to the grand jury, because I watched my buddy lose something, and he ended up sitting 6 months in jail to actually beat the case.
Do you represent him in common pleas, Roger?
I do.
Don't you do a bill of information?
We've got a common police case Wednesday. Basically, it's about the.
Do you want to waive it or not waive it?
You just want an I can't grand jury, he's got a whole, wait.
Well, waive it and do a bill of information.
Will Judge Ballard know? The only thing I'm afraid of, they won't know that this case is coming.
Well, they can probably get the bill of information ready for Wednesday.
Okay.
I don't mean to presume what you're going to do, Roger. I don't mean it that way, but I don't care.
Okay. That's fine, that's what I want to hear. He just came out of his work on. And I can wait on the grand jury. Grand jury's going to pay. So now,
Judge, let's get away with it. State what I'm building information ready for Wednesday.
Yeah, it's going to take a little bit of input by you too, but I'm going to go ahead and text Jackie about it.
I want to get it hooked up sooner rather than later. Yes, I'm on TV. I'm watching. Yeah.
If they ever come here, you know, they won't hear rush.
Yeah, well, like I said, I'll put the date on
All right, so Mr. Boyer has waived his right to preliminary hearing. The case is going to be bound over to the grand jury.
Thank you, Judge.
You're welcome.
State of Ohio versus Thomas J. Coe, case number CRA 2576 and CRB 23128 A and B, CRB 23742. Thomas Coe.
It's mine, Your Honor.
It is. He got arrested on the warrant. Looks like, from my notes, he was at Bethesda with an ankle monitor. I foolishly removed his ankle monitor on April the 14th, and he left soon after.
Correct.
I'm a very gullible, naive person when people tell me, oh, I'm not going to run anywhere. I'm committed.
Listen, that's, let me see that. It's not the grand jury.
Ankle monitor was removed April 14th, and my note
Text to Jackie.
that he left, it's dated April 23rd, I don't know if he left in that day, but shortly after. So,
This is the signature.
okay, what's the state's position on this?
We intended way back when to go ahead and take it to the grand jury. And then when he didn't show up, it kind of got set aside.
Oh, here's his files.
So I don't know whether he can go back to treatment or not.
Currently on men, I have a 10-person waiting list. So I think Focus has a bed available.
We would be willing, would agree to recommend that if, under two conditions. One would be GPS monitor, the other would be a waiver to the grand jury.
As a practical matter, without making any admissions as to what may or may not happen, I don't believe Tom Cleese will fit in with a monitor following election contact.
Oh, it was a cut.
Oh.
It wasn't cut.
It was taken off.
We took it off.
Oh, okay. Misunderstood what was being said then.
Yeah, it was, I ordered it removed and then he left.
Okay.
After I ordered it removed.
Your Honor, we would be willing to waive in exchange for that arrangement then.
I have any idea what their monitors available? This should not count as one of ours, this should be one of theirs. Because he's going through kind of footage. You want to sign a waiver or?
We'll do that, Your Honor.
Okay, I'm going to change his bond. We'll have a new bond, it'll be 10,000 cash assured. Treatment at Bethesda. Well, I guess I'll have to make it OR for.
Yeah, I was going to say, I think we were asking for a OR, Your Honor.
10,000 OR.
I think it's to Focus. I got 10 people waiting in front of him
Oh,
on
okay.
men's, yes. Focus has a bed though. She can speak with him today.
I don't know what Focus is that?
It's a residential treatment.
Okay. We have no objection to that. We can go wherever we can go.
Okay, treatment at Focus with GPS, 10,000 OR.
Thank you, Your Honor.
And he's going to waive to the grand.
Yeah, we'll waive.
Now, he's got cases here, he's got an attempted breaking and entering from 23 that he still hasn't completed, and a theft offense from 23 he hasn't completed. So we'll set those for
Would we say
release.
completed, we mean post-conviction?
Yes,
Okay.
post-conviction. Okay, I'll accept his waiver to the grand jury. On 2576. With GPS, release only to Focus for inpatient. Set review hearings on his other cases. August 15th. He has a review hearing August 15th back at this court.
May 27th, which is weird.
I wrote that down for me.
Okay.
State of Ohio versus Timmy DeMint, case number CRA 25406, A and B, and case number CRB 25407, case number PRC 213344.
All right, you're Timmy DeMint. And you're getting a copy of the charges right now. 406A is tampering with evidence charge. It alleges that at Union Township on July 3rd, knowing you were being investigated, you altered or concealed something with the purpose to impair its availability as evidence against you. That's a felony of the 3rd degree, maximum penalty 5 years in jail and a $10,000 fine. 406B, failure to comply with order or signal of a police officer. So last July 3rd, Union Township, you operate a motor vehicle to flee or elude a police officer after you were given a visible or audible signal to stop your vehicle. That's a felony of the 4th degree, maximum penalty 18 months in jail, $5,000 fine. 407 is possession of drugs. Last July 3rd, Union Township, you knowingly were in possession of Xanax, a Schedule 4 substance, and that you've previously been convicted of a drug abuse offense. It says on the complaint, an M1. So that's a 1st degree misdemeanor, maximum penalty 6 months in jail, $1,000 fine. TRC 25-1585. July 3rd, 3:18 a.m., Union Township, says you were driving a vehicle while being under the influence of alcohol or drugs, and that you had 4 priors, 2 within the last 5 years, 2023 and 2024. The others are further back than that. So I'm assuming this would be considered a 3rd offense. On a 3rd offense, the maximum penalty is 1 year in jail, $2,750 fine, 10-year license suspension, forfeiture of the vehicle if it was titled to you. The minimum on a 3rd is 30 days in jail, $850 fine, 2-year license suspension. You're also charged with driving under a suspended license. The section they charge you with is actually non-jailable. Maximum penalty, 500 hours community service, $1,000 fine. You're charged with falsification. That's a 1st degree misdemeanor. Maximum penalty, 6 months in jail, $1,000 fine. Okay, I think that's it. Then you've got old charges where it's alleged you failed to appear for review hearing on an OVI. That's 21-33-41 is the case number. 24-21-73 was a case still pending, and that's on a driving under suspension. Do you understand these charges? How do you plead to the new charges?
Not guilty, kind of lawyer.
One of those was a felony, so I shouldn't ask for the plea. Is Mr. Holt still here, or did he leave? Any other attorneys out there?
I have a loop right here.
Okay. I'll appoint Mr. Steyer to represent Mr. Dement. He's got several charges.
I might be confused on this, I just want to be clear. Are you related to Trevor then? Oh, well, that answers the question. You would be sure if you were, was pretty much it. So I want to make sure you weren't his father, because that's James Charles, so I want to make sure there wasn't an issue there.
James Dement.
James, okay, I didn't know that. I just knew the father's name. The father was, that case has been in.
What's the state's position on bond?
The state would request a $25,000 cash or surety bond.
I'll set bond at 25,000, cash or surety. That'll cover all cases.
Your Honor, that's on the bond he believes he could make. How much did you say, actually?
25,000.
If we could go to 20 to 15,000, I think he could make it. He said he'd go about $200, but I don't think anyone sells a $25,000 bond. Well, that's 2,500, not 2,250, so I'm sorry. I'm gonna ask for a 2,500 cash or surety bond. I think he could potentially make that and would still be under the control of the bonds, but I get to say whether to oppose that or not.
Well, he's failed to appear, and then these charges are pretty serious, so I'm gonna keep it at 25,000.
What did you say?
What's your availability in the next couple of weeks?
I'm available the 14th, I'm not available the 11th.
July 14th, and that'll be the next hearing on everything. For you. Pre-trials, preliminary hearings, and pre-trials. Well,
State of Ohio versus William Earls, case number CRA 25187, CRB 25188, CRB 24788.
Mr. Morpher's case.
It said it was not to the grand jury. But it's not on the conclusive evidence. I think it just happened. Not to the grand jury, May 30th. Yeah, it's not on the completion yet.
So, discontinue this until we get word from ADH. Okay, I'll set the next hearing for July 21st.
That's just an burglary. Oh, that's right. It's a burglary. That's Jackie. They asked her.
Okay, God bless you.
God bless you.
Here's one of those. I thought it just happened.
State of Ohio versus Russell Ferguson, case number CRA 25282.
Didn't you say something a minute ago?
Sir, you're Russell Ferguson?
Yes, sir.
Mr. Ferguson, you just received a copy of the charge. It alleges April 30th, Rome Township, you knowingly were in possession of a controlled substance containing a fentanyl-related compound. That's a felony of the 5th degree, maximum penalty is a year in jail, $2,500 fine, and the case number is 25282. You understand the charge against you?
Yes, sir.
You understand your rights? I didn't go over with you, but you probably heard it before. You have a right to remain silent. You don't have to say anything. You do make statements that can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, and to make the state prove this charge beyond a reasonable doubt. You understand this thing?
Yes, sir.
You have to make a hire lawyer.
Yes, sir.
You have money with which to hire a lawyer.
Yeah.
You want to hire your own?
Yeah.
Okay. What's the state's position on bond for Mr. Ferguson?
The state would not be opposed to an OR bond if it was coupled with a requirement that Mr. Ferguson be assessed for treatment and start treatment if it's suggested that he should.
I have an appointment today at 2 o'clock with the VA, and I can get my certification out that way.
Okay. Well, that's a good facility. We work with them a lot.
I mean, I think
I don't know if you're going to be able to get there by 2 o'clock, but they'll work with you. They'll work with you and they will work with the court. They'll give us information on your case and it sounds like this is the type of case, and especially since you're a veteran, that if you will be successful in treatment, you can keep your case here, not have it go to the grand jury, get an indictment on a felony, and eventually maybe even get it dismissed and not have it on your record. Okay? Is that what you want to do? Okay, so I'm going to give you an OR bond, a signature bond where you're guaranteeing your own appearance of $2,000. As long as you show up, you don't have to post any money. I'm going to order that you turn yourself in to the VA, and I'm also going to order you tell them that you got these charges. Well, you don't have to tell them because I'm going to tell them right now. We've got a liaison with the VA that works with us, and I'm going to send her a copy of your Amanda Rayburn.
I am Melissa Thompson, and I attend sites with my counselor.
Okay.
Dr. Long, Schaffer.
I'm going to send her, Amanda, a copy of your charges, so she'll know what you're facing.
So I got this one under Congress on there.
You're going to get out on your own, go to the VA, have them set up a program for you.
I already got to do that.
Okay.
Does it have my next court date here?
I haven't decided it yet. I'm not 12, so I'm not that good on the phone. It takes me a while to send stuff. Okay, so now I've sent a copy of your charges to Ms. Rayburn, so she's got those. And, okay, you need to, okay, you said you don't have one part, is that right? Are you getting a benefit from the VA now?
Yeah, 90%.
Okay, so you probably have too much money anyway.
I wouldn't say that. I don't have too much money, but, you know.
To get a quarter-point lawyer.
I do all right.
Well, I can't, if you have a certain amount of income, I can't appoint a lawyer before you got hired.
I hit about $4,100 a month.
Okay, I can't appoint a lawyer for you. So, that's up to you if you want to hire one, but the main thing is you get clean. That's what the goal is. Get clean and stay clean.
I want to rehab.
So, I'm going to have you come back. Now, let me ask you this. You have a right, it's your right, to make the state come in here within 15 days and offer me evidence that they've got a good reason to file these charges against you. Let's call it preliminary hearing. We can go further out than 15 days if you want. Or we can set it 15 days. Do you want it 15 days or do you want to go further out than 15 days?
I'll go further out.
Okay.
I'm from here and I work.
And it makes sense because the goal here is to get it dismissed and you get clean.
I continue.
Let's come back in 3 weeks. So that's July 28th, 3 weeks from today. Will be your next hearing, and then Ms. Rayburn, or somebody from the VA, probably her, is going to give me a report as to what you're doing. And what I would just want to see is that, yeah, you're availing yourself of their services and doing what they ask you to do and making progress toward getting clean. That's the whole goal. And if you do that, you can get this case dismissed down the road. It's not going to happen July 28th, but down the road when we're convinced you're where you need to be. Okay? Any questions?
Yes, sir.
You'll get out here shortly on a signature form.
I have another question.
Yes, sir.
So, when I was up here from Gal Cliff, they didn't send my clothes. So where am I going to represent that?
They sent you an orange jumpsuit? Okay. We might be able to find you something. We'll scramble around and see what we find.
That's all right. Appreciate that.
I've also got a continuance waiver for him to sign.
Okay. $2,000. Is Kim still here?
She had to go get the baby.
Okay. We'll try to get him some clothes.
State of Ohio versus Austin Hawthorne. Case number CRA 2347, CRB 2843.
Why are you in jail?
I'm an idiot in this evening court. I'm doing good, Phil.
Okay. You've been at the counseling center, right?
I haven't been going out there. No, Your Honor. He was discharged from services in May. I made,
He failed to show up for a hearing on May 27th.
yeah, I made Mr. Major aware. I was having some car issues going on.
What issues?
Car issues. I was in Lewisburg now. I got a house in Lewisburg.
Are you working?
Yeah.
Are you still clean?
Yeah. I have marijuana license.
Well, let's do a screen just to make sure. I want you to do a screen and we'll decide what direction we're going to go. Okay. I'm assuming he left against medical advice?
That's correct, Your Honor. He tried to reengage.
State of Ohio versus Anthony Merritt. Case number CRA 25103, CRA 25400.
25103, 25400. All right, can you serve here? Yes, sir. There's papers to be served. And sir, you're Anthony Merritt? Let's go over your rights first. You have a right to remain silent. You don't have to say anything. You do make a statement. It can be used against you. You have a right to have an attorney, to have one appointed if you can't afford one, to have bail, to make the state prove charges beyond a reasonable doubt. You understand those things? You've got, looks like 2 charges. The most serious one is 25400 case number. It's a domestic violence felony level. It's alleged July 4th in Union Township. You knowingly caused or tried to cause physical harm to, I think this must be a typo.
I believe it is.
Crystal, should be Crystal, shouldn't it? Crystal.
Yes.
Crystal Atkins.
We moved to amend that, Your Honor.
And is that, I don't see, I know you're telling me it's Atkins, but in the affidavit, I don't see her name. Last name, I see first name only.
The second line of the first word on the second line is her second name, is her last name. A-T-K-I-N-S.
A-T, okay. I'll amend it then to allege she's the victim.
But we got Crystal spelled wrong, so. I'm assuming it's K-R-Y-S-T-A-L. Is she here by any chance?
Crystal Atkins here?
No.
It is K-R-Y-S-T-A-L.
Okay, I've amended it to allege that. So that's a felony level domestic violence, and it's alleged to be a felony because it's alleged you had a prior conviction for domestic violence. Felony 4 is 18 months in jail, $5,000 fine maximum. And then you got a misdemeanor 2. That is both don't know. They're both felonies. 25-103. It's also a felony. It's not in the file. I don't have a copy in the file. It's just a blank file. All I have is a consent agreement. What is the 103, 25-103? It's a theft offense. It's a felony file theft. I'll need a copy. It's alleged that you took property belonging to Crystal Atkins and they charged it as a felony file. So the maximum penalty on that's a year in jail, $2,500 fine. Okay, well, it's, I don't know that, it's still pending, so. Do you have the money to hire a lawyer? Do you have a job? Where do you work? Okay. Are you paid by the hour doing that work? How much per hour?
32, but I ain't even made back to work.
You're not working right now?
They told me to come into work and I went to chill.
Yeah, well, when's the last time you worked?
It's been quite a while.
Months?
It's been, well, I got out of prison. And I ain't worked till I got out of prison.
I'll appoint Roger Smith to represent you. State's position on bond for Mr. Merritt.
State would request a $5,000 cash or surety bond.
How much? I'm sorry.
$5,000.
$5,000.
And we're going to ask for a protection order as well.
She says he's going to award me more than $100, which I don't think Gary Sowers has a bond that low.
Right.
I would ask for no more bond or if it's worth $1,000. Yeah, sure.
Okay, I'm going to leave it at 5,000. Set then fairly soon for preliminary hearing next July 14th for preliminary hearing and pretrial, and well, they're both preliminary hearings actually. Okay, and I'll order for you, if you do make bond, you're not to go around or contact Crystal Atkins.
Just for your information, Kim has been contacted by Mr. Ferguson. State of Ohio versus Sarah Schmidt, case number CRB 25404, A and B.
We get a date for it to come back.
Sarah Schmidt. Ms. Schmidt, it's alleged that July 5th, Fayette Township, you tried to deprive Walmart of property without their consent. So theft offense, maximum penalty 6 months in jail, $1,000 fine. You understand the charge? You understand your rights? How do you plead to this? I didn't understand. Okay. Guilty means you're admitting it's true and you're waiving your rights to trial and lawyer. You understand that? I'll accept your guilty plea. I've got a Charleston West Virginia address for you, is that right? Kind of far from home. Oh, also, I missed this, you had another charge, criminal trespass. Same date, time, place, they're saying you came on the premises of Walmart without their consent. So what that tells me is you had a prior shoplifting charge somewhere with Walmart, so they didn't want you to come on the premises. Do you understand that charge? So how do you plead to that one? Okay, well, my standard on shoplifting, and because I get so many people that are dirty, I'm going to have you do a urine screen. So to see what the status is. I'd say 80% of the people that come in here shoplifting from Walmart give me a dirty screen. So go do a screen, we'll see what it shows. And I'll recall you after you get the screen.
State of Ohio versus Brian K. Schaffer, case number TRD 24819, A, B, and C.
Sir, are you Brian Schaffer?
Yes, sir.
Mr. Schaffer, it's alleged April 22nd of 2024 at 7:40 a.m. in Fayette Township, you were driving a vehicle with a suspended license, and it's the variety that's non-jailable. Maximum penalty is $500 community service, $1,000 fine. States also was alleging you weren't wearing a safety belt, that's a mandatory $30 fine. And that you failed to stop at a stop sign. That's not jailable. Maximum penalty, $150 fine. Now, some may ask that are sitting there watching, why is he in an orange jumpsuit if he was charged with 3 things that are not jailable? It's also alleged that you didn't appear in court as you were ordered to on May the 14th, 2024 for traffic court at 4 p.m. and a warrant got issued for failure to appear. So do you understand the charges?
Can I speak a minute?
Absolutely. Now's the time.
I've quit the dirt roads pretty much. You know you ain't sending me to prison today. Usually when I come in here, I've done robbed everything on dope and all this and that. I live in camp in the middle of the woods. I've got no means to go get my license. Okay, look, I've got my drug habit down to pretty much a minimum. Well, pretty much. It's the truth. I used to be horrible. I need to go somewhere with moderate care to where I can get my shacks with my license and quit coming in front of you. I'm tired. Jackson, yeah, it's just wearing me out. I can't work it.
Well, but you got to come to court when you're ordered to.
I probably didn't have a way to get here. I live in the middle of the woods in Jackson.
Well, let's see.
I have no family no more. My brother's crazy.
Well, here's the other problem. I mean, it wasn't just you got stopped for not having a driver's license. They're just like, oh, here he is. There's Brian, let's stop him. No, you had a rap. You had a rap with somebody else, so.
If I could get my license back, a lot of this would go away in my life.
Well, what do you, if we do a urine screen on you, what's it gonna show?
A box of marijuana right now.
That's it?
That's it.
Well, let's do one and see what it says. Go do a urine screen. Okay. Maybe it will, but I've been lied to in open court before, so it would be the first time if it shows something else.
State of Ohio versus Charles Frederick Lake Jr. That's number CRD 25405.
Okay, well, I'm afraid, is he having DTs or what's going on with him?
Yeah.
We need to get him treated. Alcohol withdrawal is a serious business.
Oh my God.
Yeah. With opioids, you think you're going to die of withdrawal, but you're not. Alcohol, you can die from withdrawal. So, it's just a disorderly conduct. Let's have him, he needs to be transported to St. Mary's. I order that. Somebody pick him up, take him to St. Mary's, Ironton, get him treated. And then we'll go from there. You got family here?
Yeah.
Okay, you're the son?
Yes, sir.
Is he living on his own or what?
Yes, sir. He's living on his own. He has a long history of alcohol.
Is he a veteran?
He gets out of them.
Is he a veteran?
No, sir.
Okay. Well, there's plenty of, how does he pay for medical services?
He lives on SSI, so he gets Medicaid.
He's got Medicare?
Yes, sir.
Unfortunately, that makes it a lot harder to get treated. Brianna was here from OVP. She leave? Okay. OVP would be a great option for him. You want to take him to this right here in Burlington, inpatient. He needs inpatient.
Yes, for sure.
Needs inpatient.
Yes, sir.
You could try there, but you may need to go to the emergency room first. She leaves.
Yes, sir.
Talk to Mr. Cooper. He can get you the contact information.
Okay.
And so let's have somebody transport him. Can we get somebody from the sheriff's office to come transport him? He needs emergent care, and I'm just going to delay. I mean, it's a minor misdemeanor disorderly conduct. It's not even jailable.
Right.
My main concern is he gets treatment.
I'd like to, if it's okay, for him to complete the course or the rehab, just to.
Yeah, here's the only thing. I can't do anything with him because I can't make him because he's only charged with a non-jailable offense. So
I understand he physically assaulted me about a month and a half ago.
Okay.
And I'm getting to.
We got to get the alcohol fixed.
We can't get him to stop.
Okay. The only thing you can do, if you have the means, you can do an involuntary commitment. But you're going to have to hire a lawyer to do that. Does he live in Lawrence County?
No, sir. He lives in Huntington.
In Huntington, okay. Actually, it might be a little bit easier over there. You can get some, probably a little easier to navigate the system over there and get some sort of involuntary commitment.
Okay.
But OVP would they'll take West Virginia, they'll take Medicare. So, and they're in Huntington too, but they're inpatient facilities right over here, really close. But he needs to go to the hospital for that.
Okay.
Okay, I'm going to order them transport him, pick him up from the hospital.
My wife has a protection.
Well, but not you. You don't have a protection order. You're his son, right?
Yes, sir.
Okay, you gotta step up. Now's the time. I said he helped you when you were a kid. If you wanna walk away, walk away.
Well, originally that's what I did because he
Well, look, there's nothing I can do. He's charged with a disorderly conduct. It's not jailable. I can't do anything to make him get treatment. I'm just telling you what needs to happen. And you need to make it work. You're his son.
I've been trying to, but he's physically assaulting people and calling my family names.
Take him to court. Get an involuntary commitment. Look, he can't tear out a one paper bag. You're a healthy young man. He can't do anything
I
to you.
understand that, sir, but he's driving around drunk all the time. That everybody's
Okay, get it stopped. Family, get it stopped.
I'm trying to.
Okay, I'm telling you how to do it.
Thank you.
We got a deputy out here. Or next time charge him with something more serious. because there's nothing I can do with this order.
Deputy left.
We need to get some call, let's call 911, have them EMS transported. They're right next door. And probably not St. Mary's, I said St. Mary's in Ironton because I was thinking he was a Ohio resident. Take him St. Mary's, West Virginia or Capital. That's where he needs to go, he's a West Virginia resident.
We can go ahead and nolly that charge.
They're just nolly.
If he goes to St. Mary's and Ludington Judge Schaffer, there might be a possibility that they'll put him in the hospital for that.
If that guy's still out there, tell him that he's gonna go to West Virginia, not to St. Mary's. Yeah, he needs to go, he's a West Virginia resident, so let's have him, well, call, let's have the EMS transport. Yeah, they can transport him over there, you guys don't have to.
State of Ohio recall 6 Lee Sue Bentley. Case number CRA 25359, CRB 25360.
Never a dull moment.
Never.
Okay.
That's correct.
Is there ankle monitors available? Is that? Okay, I gotta have a talk with you. If I put an ankle monitor on you and you cut it off and leave, you're gonna go to prison. And that's no joke. And it'll be out of my control. You're gonna automatically go to the common police court, which handles the felonies. They're going to file a felony against you. You're going to go to prison for cutting the ankle monitor off. Everybody that's done it has gone to prison. So you're in a position where if you go to treatment and are successful, you can get this charge dismissed. So you're going from here, on one end, your charge is dismissed and you get clean. On the other end, you've still got an addiction problem and you go to prison. You choose. I think the smart play is to go to treatment and stay and get clean and have a life. How old are you? 32. Okay, you probably got another 60 years at least, average life expectancy, if you get clean. If you don't get clean, it ain't gonna be that long. I'm just telling you, you're not gonna live that long. You're not gonna live to old age. I don't know if you care about that. When you get my age, then you start appreciating being old. But you're a young person. You got kids? Okay, you want to see them? Well, the only way you're going to see them is to get clean. Well, you don't know that. Okay, well, your choices are to keep using or to get clean. If you want to keep using, cut the ankle monitor off and go to prison for a while, then come back, and you'll learn even more criminal stuff while you're in there and make criminal friends, and then you'll come out and get in more trouble when you get out and probably still have the addiction that you went in with. So those are your choices. I'm giving you the unvarnished truth. I want you to get clean for you. How old are your kids? Can't be that old. Wow, 4 of them. 5. You know, they may want to see you at some point if you get clean. There's always hope. Okay, so you're going to at least tell me you want to get clean and go to treatment. Okay, and you know the alternative. The only way you can leave is cut the ankle monitor off, because if you leave with the ankle monitor on, they know right where you are. It's pretty easy to find you with an ankle monitor on, really easy. So the only way you can get away is cut the ankle monitor, but then when they do find you, you're going to go to prison. You understand? Okay. So I'll order you released to the counseling center with the GPS monitor, and the reason I'm doing this is because I let you go before without an ankle monitor and you left. So now you gotta go with an ankle, so that, we've upped the ante now. You've got an ankle monitor on, you gotta stay. So let's come back for, just to see how she's doing on the 28th of July.
What date did you say you're on?
July 28th?
Yes.
With the monitor.
Thank you.
State of Ohio, they call Sarah Schmidt, case number CRB 25404, A and B.
Okay, amphetamine, do you have a prescription for that? I couldn't hear what you said.
For my leg, is there anything I can think of? Because I have cellulitis and some other problems, but it's only I can think of.
Do you have a prescription?
I mean, no.
No, okay. That's the only thing you tested positive for. And you've got a daughter at Marshall?
No, we're looking at college.
Oh,
Yeah, she went there for an event that they had done in Huntington.
and you found your way over to Walmart?
Well, I have a friend that lives in Moscow, and there's one that lives in,
Where's your daughter now? She,
she went back home by her sister.
okay. Anything else you want to tell me about this?
No, it's great.
Okay. You've been in jail since Saturday, I guess, right? Okay. You need a case number? 404. Okay, on the theft offense, I'll impose a $100 fine, order you to pay court costs, 10 days in jail. I'll suspend give you credit for 2 you've already served. Order you to do 5 days community service, and you can do that in Charleston at a legitimate charitable organization. Somebody that's got letterhead, like Salvation Army or something like that, where they can send us a letter saying you did 30 hours community service.
I know some like Goodwill, but that was.
Goodwill's fine, yeah. Okay, you'll have a review hearing in January. That's a long way away. It gives you a lot of time to get this all done. If you do get it all done before then, you don't have to show up.
Oh.
If you don't get it done, then you gotta show up, explain why you didn't finish it, and if you don't show up and have it finished, you get a warrant. So I don't want you to go to jail anymore, but you could go to jail if you blow this off. You don't look like the person that would blow it off, but I get surprised a lot, like the guy who wanted his ankle monitor off, and he was doing so good in treatment, I took it off, and he took off immediately after, so. Okay, well, I'll take care of, and you have trespassing, that's a $50 fine. And your order, stay out of Walmart, double order, stay out of Walmart. So, there's other places to shop besides Walmart.
Understandable.
Okay, January 12th is your review hearing. If you forget, we have phones here that people will actually answer and tell you. And we have a website where you can go put your name in. It has record search, Lawrence County Municipal record search. Put your name in, your case will pop up. It'll tell you what you gotta do. Or you can call and talk to the probation officer
How long do I have to do
until you get it done.
it?
Just as you're making an effort, I mean, maybe I shouldn't say this, but it's true. I'm not supposed to put people in jail for not paying a fine unless it's willful. I mean, they used to have, back in the day, talking about a few hundred years ago, debtor's prisons. You ever heard that? If you couldn't pay your debt, they just put you in prison. We also used to have stocks where they could put you in the stocks rather than jail, put you out in front of the courthouse, your hand like this, and people come by, throw stuff at you and make fun of you. Not allowed to do that anymore. So the only thing I got is jail. I mean, I give people chances not to go to jail if they'll pay their fine, do their community service, and they blow it off. You have to go to jail with them. Don't be surprised. People act surprised. I'm going to jail. It's the only thing I've got. You won't do it. So if you're making an effort, I'll work with you. Just whatever you can pay till you get it done. And you can actually do extra community service. If you can't pay, you do extra, we'll give you $50 a day credit for every extra day of community service. Okay, good luck to you and your daughter. Okay, that's all.
Your Honor, we're still waiting on some hearing screen results for a couple of the inmates back there.
Okay.
State of Ohio recalls Brian Schaffer.
Give EMS. Okay. Okay, you were right. You told me THC and buprenorphine. Are you getting that prescribed or? Okay.
I mean, I'm trying to help sell. I've been in trouble so long in my life, Mr. Captain. I can't even get out of trouble I was already in from years ago.
I understand. And every time you get one, it just digs the hole deeper.
Yeah,
Right?
they say it's not jail or offense driving under suspension, right?
Well, it
Ohio
depends.
says different.
I think they probably could have charged you with jail. Well, the only reason you're in jail is you didn't come to court. I mean, you were cited in the court, and then you didn't come, and then you got arrested on the warrant for not appearing. So you made it jailable by not appearing.
Driving under suspension is not jail no more.
There's different varieties. No, there's different. There is a variety that is jailable. There's a variety that's not jailable. It depends on what the officer charges you with. And here he charged you with something that wasn't jailable. It was a unclassified misdemeanor, which means you can get community service and fine, but no jail. So, but now that you got this, and you had no proof of insurance, so that every time you get one of those, it makes it harder too. So I understand. But you got a South Point address, is that not right? What's your,
My current address is wherever you put it, because I don't know my address. I have no mailbox. I live in Cameron on top of the hill.
where, what?
Jackson.
Oh, in Jackson, not even in Lawrence County?
Not right now, I mean.
Did you get arrested in Jackson and sent down here from Jackson?
Yeah, I got
Okay.
there driving under suspension.
Okay.
I got to get around. I got to go to the grocery store.
I understand that.
Now I ain't got no car to look at.
It's not like New York City where you can catch a subway, you know, when you live in a rural area, you gotta get around. But you gotta have a license too, so I don't know the answer to that. Are you working?
Yeah, most of the time.
Okay.
Not taxable. Yeah, I do get to do something every day.
Okay. How long you been in jail on this one? Thursday. That's a bad day to get arrested. There's no good day, but that's a particularly bad day. State take any position on this?
No, Your Honor.
Yeah, the bad thing is, though, I'm looking at this, well, let me ask you, I didn't even ask you, we got so caught up in your backstory. How do you plead to these charges?
I did.
Okay. The problem here is, I mean, somebody, I don't know if you were at fault, who was at fault here? We got a crash report, and you didn't have insurance. So that's bad. Looks like it was pretty decent wreck. I don't know, I gotta read this report. It's several pages, so let me read it into the record. Unit 1 driver stated he did not sustain any injuries. I think that was you. I think you were Unit 1. Let me make sure. Yep. Brian Keith Schaffer is Unit 1. Unit 2 driver stated she sustained the following injuries: back, neck, right arm, chest, collarbone. Unit 1 sustained the following damages: hood, front bumper, grill, left fender, right fender, windshield. Unit 2 sustained the following damages: left front door, left rear door, left fender, left quarter panel. Dry pavement, clear skies. Unit 1 that you said he did not have a valid license and did not have insurance on his vehicle. Unit 1 driver stated the windows on his vehicle fogged up and he couldn't see. Stated he was wearing a safety belt, although there was an area in his windshield directly above the steering wheel that was broken and spiderweb. There was also a hair in the windshield where the impact occurred. Unit driver was suspended. Okay. That's pretty much it. Well, hopefully this poor lady had insurance, full coverage on her own vehicle, or she didn't get her car fixed because you didn't have liability coverage. She's just out of luck if she didn't have insurance, full coverage. Even liability, she had liability, wouldn't cover the damage you did to it. So I don't know if we want to try to get in touch with her, Mr. And see where she's from. The owner of Unit 2 was Valerie Good, South Point. So she's local. It was a fairly new car, 2024, and it says she does have insurance with Progressive. So hopefully she got her car fixed. But it was towed, so it was enough damage that had to be towed. So
We could contact her. We don't have the file, we'd have to get the court's file.
you want to try to contact, I've got a phone number in here. I'll circle it. You want to try to contact her today? See?
Yes.
I'll put a circle in blue ink. Okay. We'll see if we can get a hold of this lady, see what she's going to say about damages. It's kind of, though, like how many angels can dance on the head of a pin, because I don't think he's going to be able to pay damages. But at least in theory, we'll find out how much it is. Okay, we'll have you back out and see if they can get a hold of her.
State of Ohio versus Carissa Damron, case number TRC 25709, A, B, and C. Your Honor, this is set for sentencing, but there was a request that it be called.
Okay. Mr. Morford's case. Okay, so sounds like things are going okay, but things are still being worked on?
Yes, she's doing actually excellent. She does have areas that she needs to focus on, and we're trying to do that with her, but she's a great client.
Okay. Well, I want you to be successful, period, but, I mean, I'm assuming at some point we're going to transition back out to where you're around other folks that may have been a problem in the past.
I actually moved. I'm in the process of moving. But yes, I am.
Well, I'm reading the report. It sounds like there's some people that you really can't change your relationship where there's been a problem,
Yeah,
because there's blood there.
Yeah. that's-
Right.
Yeah, it's
And
rough.
that's not uncommon.
Yeah.
So you gotta figure out how to deal with
Just
that.
gonna have to set the boundaries and healthy ones.
Okay. So we're not done yet.
No.
Okay. Let's keep working. September?
Good to hear you. I'm pretty much free in September, Judge.
Okay.
I'm free then.
September 19th will be the next hearing.
Thank you, Your Honor.
Thank you.
Okay, good job, keep working.
Okay, thank you.
State of Ohio versus Brittany Eplin, here at the court, case number CRB 23589,
Mr. Morphin's case. He's at the Counseling Center.
I just wanted to ask him something. 'Cause when he was here, the last judge said, since my progress report was good, that they would consider me switching to a different facility, closer to home. Because I have a job down in Ironton and everything.
There are things going. The report looks good.
Things are going pretty well right now, from what I understand.
Good.
I was actually wanting to say something.
Okay.
When you wasn't here on June 6th, I think, or June 2nd, the other judge said that if my progress report was good, that you guys would consider me transferring closer to home. I know I have a job down there. I want to start schooling down there. I want to be closer to my family. I want to stay in treatment, of course, and
Okay,
finish.
well, how are we gonna make that work if you're working in Portsmouth, going to school in Portsmouth, but,
I don't have a job in Portsmouth, but I have a job in Ironton.
oh, okay. Now you do?
Yes, I talked to him during the weekend. He said it could work, yes.
Okay, so what's being recommended?
It's not our recommendation, Your Honor.
Okay. Do you have some place that you're wanting to, is this gonna be to inpatient or what?
I mean, I plan to stay in transitional, of course, where my same level of care is, either Lawrence County Recovery, just anywhere at this point, closer to home, UFR, anywhere that would take me.
Okay. I'm looking at a report from back in May, it gave me some pause. And this was actually addressed then in May, in the report. And- Okay, I don't think we're ready yet, so I'm not gonna agree to it at this point. Maybe in the future, but not now. You're doing well, and I think you need to stay where you are. Because you've had some issues before, and I don't think it is warranted to change things up at this point. So I'm going to deny it. Let's come back, I'll reconsider it next time, and we'll do it in a month.
Thank you, Your Honor.
Let's do it August the 8th.
Judge, I've got a trial in front of Judge Finley then.
Okay. August the 15th.
I am free.
August 15th will be the next hearing.
10 o'clock.
Thank you, Your Honor.
Thank you, Judge.
You're welcome.
State of Ohio versus Shane Sowers, Case number CRB 25-186, CRB 25-255.
Mr. Morford's case for pretrial.
I left him a message. Supposed to call him back. Tried calling back again and they didn't answer.
How's he doing?
He came in for a substance counseling assessment. So he comes back in Friday for another mental health assessment on the other day. But he's trying to switch different days because of his work schedule. But as of right now, he's going to continue to stay with us until he gets his place.
I pretty much panicked, and I need to like say some stuff because I didn't get to say it last time. So basically, I thought it was a gun and he had a cigarette.
My question is, if you want to cancel,
Yes,
how's it going?
it's good. It's better. Or not, are you talking about like mine, Shawnee, or the other place?
Well, you're both going to some parenting classes, at least that's what we're discussing.
Yeah, my medical, something happened with my medical, and I don't know what happened, so I was trying to get a hold of them today, and they haven't answered yet. So that's the only issue.
Is he doing okay?
Yeah, we're doing perfect. I just want these charges dropped. I don't think he deserved them.
Came in for a substance use counseling assessment. The parents on the mental side come again Friday at 3 o'clock. But he's really good. So he wants special therapy days because of his work hours. But as of right now, he's coming to us Friday at 3 o'clock.
He's wanting to go to Old Grove.
Your Honor, do you have the 25 CRB 186 file?
I do not.
That is misconduct in an emergency, and it's also pending, and I don't know where. Oh, maybe it's never been arraigned.
Well, let's see. File I've got covers this 25-186, but then when I open it up, 25-255 is what's in the file. Let's see if there's 25-186 must be in here too.
186 is what I've got, Your Honor.
There's a 25-255, which is a domestic.
I understand.
Miss Dunn's statement.
Yeah, there's references to both case numbers.
Situation. I'm sorry I have to intrude in your life, but you put us here.
But I don't see the actual complaint on 186. No, I do have it. 25-186, I have it, both. It's from March 18th, the domestic's May 1st.
So, I guess, Your Honor, and I think he's been arraigned on that, but I'm not sure. It really kind of helps to further shine a light on some of the challenges that have been going on in their household. I've got some real concerns to make sure that everything is okay. We're glad that Mr. Sowards is doing the treatment.
And we're getting along.
And they're getting along. But
I just want these charges dropped.
I know.
It's pretty much a situation where I'm freaked out. And I've had counseling and everything. I was doing this, he knows about.
So how's the state want to proceed?
Both of these affidavits that are part of the charges are concerning because I believe that there's mental health issues and a lot of disorder in the home that I'm fearful that something worse is going to happen. Ms. Sowards is here urging me to dismiss the charges. It's all a big mistake. And I just think that there's too much here to simply ignore what's being alleged. Now, on the other hand, we want Mr. Sowards to do the treatment that's been recommended because we believe that that should be the proper outcome of this case, not necessarily trying to put somebody in jail or anything like that. We just want to make sure that the family is operating, functioning as it should. And today I found out Ms. Sowards says it was all a big mistake. It wasn't a gun. It was a, what do you think it was?
It was a pack of cigarettes.
Pack of cigarettes. It wasn't a gun.
I pretty much went into a panic attack and my mental health wasn't right and I'm getting help now. And I'm currently pregnant and it's just a lot going on.
And I want to assure her that we're trying to put her in a better situation and not make her life worse. But we believe
But we're
that
doing good, Your Honor.
they're doing good, which is a good thing. We don't want to dismiss the charges. We want to make sure they keep doing good. We also want to encourage Ms. Sowards to keep attending to her pregnancy and her mental health.
Could we just like do our parenting classes and everything still and get the charges dropped if anything?
That's what we want to do. We can't do it today.
Is Mr. Sowards, is he getting counseling?
He started, yeah, he went in for an assessment, he goes back again Friday on at 3 o'clock today.
Okay, and you think he can help?
Yes.
Okay. Is he, I read in one of the affidavits, there's some medications he should be taking. I don't know if he this, but the condition is commonly has medications, and so I don't know if that's the kind of thing RRS can deal with.
I was never on medication other when I was a kid.
Okay.
And I was for ADHD.
There was a remark in here about being bipolar, so if that is the diagnosis, that's treatable with medication, my understanding. Is that something you can look into?
Yes.
Only thing I was really diagnosed with was ADHD, and I grew out of it.
Well, there's some things in these affidavits that give me great pause and concern. So I don't feel comfortable dismissing those either. You primarily, ma'am, are the one that I'm concerned about, because if the affidavits are true, you were at some risk. So I'd like to see, you say you want to stay together and have a good relationship and good marriage, and well, that's what I want for you too, but I don't want to see you get hurt.
Trust me, I know he would never hurt me. He loves me with everything.
Okay.
He
Well,
has never hurt me.
let's just keep monitoring things and agree that he's going to go continue to get some counseling and help. And then, it sounds like the state's not opposed to dismissing it down the road if that happens. I just don't want to see something bad happen to you.
But could they get dismissed though, with us
Yeah.
keeping up the good work?
I mean, he's not saying that they're not going to dismiss it.
I want it to get dismissed, but not today, and I want to make sure you guys are okay. Okay, so that means both of you too. All right? You don't have any charges here, but I want you to be well also.
So you're not available the 8th. Now, we just had one for the 15th for you, Mr. Morford?
Yes, Judge.
August 15th.
State of Ohio versus Kiara Smith, case number CRB 25-312.
And what about the 15th? You're good.
She said August 15th. Stating that my daughter was sick.
Sorry?
Stating that my daughter was sick in his house. He wanted to work.
Mr. Morford's case, pre-trial.
August 15th.
Judge, a report that Mr. Cooper's handing you is proof that her daughter was sick at the time of this incident. That's why she was left in the vehicle.
I'm sorry, I don't understand what you're telling me.
That shows that her daughter was sick when the child was left in the vehicle while Ms. Smith went to renew her license.
So I assume the problem is, was it hot, or what was the circumstances? How was a 17-month-old child?
Judge, in addition, I would add that Children's Services Division has been involved and cleared the case.
Okay. What's the state want to do with it?
Well, previously, we had discussed a guilty plea, which was declined, but and it is the case about children's services. We'd like her to do some parenting classes, and we would dismiss the charges.
I'm okay with that.
Okay, do you know where they're offered? Where can she avail herself of that?
Maybe NECO or something like that, or I don't know if these other agencies here provide that or not.
Everybody's raising their hand. Parenting.
I know there are agencies that provide it because they do it in children's services cases.
I think Mended Reed's might.
Mended Reed's.
Also. As
Okay.
well.
So we're going to let her pick an agency and come back?
So I don't know any agencies. I don't know.
She doesn't know any of the agencies, does
I live in Lawrence County, Kentucky, by the way, in Louisa.
Oh, okay, well, you're going to have to go there then. Do you have a medical card?
I do.
Kentucky?
Mm-hmm.
You're going to have to go, you'll have to find an agency in Kentucky then to go to.
Okay.
Get a parenting class. I don't know if ARC does a lot. I don't know if they offer, ARC is in the facility, used to be Belmont Hospital.
Mm-hmm.
Maybe Pathways.
Pathways is in Kentucky too.
Yeah, I think they offer services. How long do I have to do this for?
That depends on the provider.
Okay.
I wouldn't think it'd be too very long. A couple months max.
Okay, when you want to come back, Mr.
Judge, you mind doing about a month and let her get established with an agency?
The 15th?
Yes.
August 15th, for a free trial, 10 o'clock.
What time, what date you're on?
August 15th.
Thank you, Your Honor.
State of Ohio versus KCA Burton, case number CRG 24-129. Your Honor, this was set for
This is Mr. Morford's case.
Do you have any objections, Mr. Hill?
Objection to?
Expungement. Casey Martin.
What's the time frame, 45 days? Is that what it's supposed to be said?
Yes.
Because we haven't been real strict on that, and then they kind of came back to bite us on the case. And then something, we'd already approved it, and then something came up where it probably shouldn't have been approved. So we need to start observing that. It looks like this one was filed in May the 12th.
I think it hasn't been a problem when we scheduled hearings, Your Honor. It's been,
When they just present an
when they
entry.
present an entry at the same time the motion's filed, it gets signed.
I don't have that with me today, Your Honor.
It looks like it's theft offense.
Yes, Judge.
Well, it looks like the time frame is appropriate. And let's pull up that, it's 24/1/29. I don't see that the community, there's nothing noting that the community service has been. I wonder if it's in the file. Yeah, it looks like it is. Okay. Prepare an entry.
Will do. Thank you, Your Honor.
State of Ohio versus Laura M. Smith, case number CRA 25372, CRB 25373.
We got Rich.
She was taken to the psych hospital and checked herself out.
It's my understanding, I talked with Brianne, she told me that she double-checked, but she never came back. She doesn't know where she is, and unfortunately, I don't have any contact information, but she was homeless at the time she was arrested, so I'm not sure until she gets picked up.
She does have a felony pending.
Yes.
So I guess the question is, do the state want to issue warrant from here or from the common pleas?
We would just as soon have the warrant issued from here, Your Honor.
That would be a warrant issued from here for failure to.
Thank you, Your Honor.
State of Ohio versus Tyler Sayer, excuse me, I'm not sure. Tyler Rain, sorry. Case number CRA 25101.
Mr. Steyer's case.
Your Honor, Mr. Lane is at TCC.
Your Honor, I don't have a report for Mr. Lane. He hasn't met with case management yet. What I did do was call ahead and just kind of see where he was at with staff. There has been no negative reports about him, and they say that he's adjusting well.
Okay, good. This is his first hearing.
What sort of a timeline are we looking at to come back, Your Honor?
3 to 4 weeks, I would say.
I'm here the 28th, that's 3 weeks, and I'm here the 4th, that's 4 weeks.
Let's do the 4th.
Okay, August 4th, 10 a.m.
Okay, good start.
So I'll send an email.
Thank you.
You're welcome.
Thank you, Your Honor. John A. Barker, case number CRB 23115, CRB 23116.
Okay, this is a recall with Barker with his counsel. It's an older case. This has been out of pocket.
She came in and dropped the charges. I don't know if they
Judge,
have or not.
we spoke a little bit earlier today, and it was his understanding she came in to drop the charges. He thought, and he was not correct, but that meant the case was over. What wasn't officially dropped.
One of these is an OVI.
Yeah, the OVI wasn't, I honestly, my mistake was that where I went to court over all of it at the same time, and she came in and dropped the charges. I was traveling back and forth from Maryland to Ohio, dealing with custody with my son where his mom went to prison. It was just a lot. I honestly lost track of what I was doing. I've been traveling back and forth to Maryland, dealing with that since 2023, like the beginning of 2023.
You're still local, are you in Lawrence County?
Yes, I still live here in South Point.
Judge, he's in South Point. It's an excuse, I don't know if it's a good excuse, but he did have another case pending, which...
So we've got, let me just make sure we are all on the same page, what's pending. 23-194, A, B, and C is OBI, a driving under suspension, and some sort of problem with a muffler, it looks like.
Oh, yeah, exhaust.
Then there's also 23-115, that's endangering children. That's due to the OBI, so unless you had a minor child with him in the vehicle, at the time he had the OBI. So then there's got another file, 23-116. And he got arrested on this, that's when there's a bond posted now.
The domestic violence. That's what she dropped.
Domestic violence from February of 2023. So those are the charges pending.
Judge,
The bond covers all the cases, not just the domestic.
he's local, has a bond up, he's assured me if you'll give him another pretrial date, I'll look into his cases and he will show up.
Yeah, I'll be here. I don't have any cases going on. I don't have to be in Maryland for a long time now. All that's done over the phone for now.
All right, how about the 28th of July? Are you available?
Yes, Judge, I am available.
All right, July 28th will be the next hearing, so withdrawal of the warrant.
Thank you, Judge.
Set these as pre-trials for July 28th, 10 o'clock.
Your Honor, on the OBI charge, it's been long enough now that we have the results back.
Okay, you want to announce those?
Methamphetamine positive, and also THC metabolite.
Okay.
And he had children in the car.
Next hearing, July 28th, 10 o'clock.
Thank you, Judge.
State of Ohio versus Stephen Stanley.
You got that,
Case
right?
number CRB 25225, CRB 25227. Your Honor, this was originally set for trial, but I understand
Mr. Smith's case, the cases were set for trial.
Correct, Your Honor.
Your Honor, I would like to be able to have a moment to speak to the alleged victims and make sure that we're okay on everything.
All right. While you're doing that, we're going to do one other case.
State of Ohio recalls Summer Crank, case number CRB 25198. Summer Crank.
She's in the back. Okay, how was it back there? Boring? I figured with all those prisoners back there, it got a little exciting. Well, I'm assuming you don't, I mean, this is like the Hilton compared to the main jail, so you don't want to go to jail, do you?
No.
You gotta take care of this stuff. So you gotta take care of this stuff. I mean, if you're only gotta pay $25 a month, it's gonna take more than 3 years for you to pay this off. And that's not acceptable. Okay, so you're paying 25 today, and you're gonna pay more next month, right? Okay, well, I'm gonna set you review hearings on a monthly basis, so I'll set your next review hearing for August the 11th, so it's a Monday, August the 11th. And I'm releasing you to start taking this seriously and get it done. Especially I want this restitution paid to this person. I don't want to dribble and grab it out $25 a month for them. I don't care, that's all filed, that's done. You have an order that you have to pay this, so that's what has to be done, so you gotta pay it. Pay something the next month more than you did this month. August 11th, your next hearing is 9 o'clock. Okay, you can be released.
Well, we can, sure.
Yeah, Judge, apparently we're going to do, I guess what amounts to a diversion where my confident or guilty plea will be held in abeyance in 90 days. If there's no further problems, be dismissed.
By way of explanation, Your Honor, the
Thank you.
Brandon Fry and Paul McCoy was the driver of the vehicle. Paul, it turns out, has bought the house right next door to this gentleman. And this is what happened. What happened at the time was that they pulled up in front of this house next door to Mr. Stanley and were there for a few minutes, and I guess Mr. Stanley perceived it as some sort of a threat, and he ended up firing his gun. Of course, it scared them to death, and they took off, but he bought the house next door. And what he really wants to do is he wants to make peace with Mr. Stanley, because he may either be living next door at some point, or at least he'll be there working on the house. Sure. I mean,
Honestly,
the judge-
this house I bought has been broken into over and over and over and over. And I honestly think the man thought I was down there up to no good. And I haven't had no contact with him or anything to even speak to him. And I closed on the house Thursday, and I've been down there all weekend, have no more altercations with him. So, like, I really don't think we'll have no more trouble.
Won't be no more trouble.
I mean, I've known of him, all my buddies know him very well, so.
He needs to call the sheriff instead of taking matters in his own hands, I've told him next time.
Absolutely.
Yeah.
Because he perceived he was a
And he did
burglar
after
and
that.
trying to scare him off, which isn't, it is what it is. So,
So my idea was, because of the fact there was a gun used and shots fired,
And
regardless
I'm
of the
taking it this
circumstances.
wasn't in the middle of the night or anything like that.
No, it was 4 o'clock, 5 o'clock.
Evening time?
Yeah.
So that's the reason why we really didn't want to do just a straight 90-day continuance. Although really the effect, I guess, is the same. If there would be problems, we certainly could pursue the charge, but at the same time, if he's already entered a guilty plea, then he could just be sentenced for creating a problem. Not that I think he's going to, but it's an unusual situation.
I was in favor of just not, I don't know, because we do a plea, do we have to set aside the plea, or is there a diversion the court has that, I thought it'd be easier just doing 90-day. And speaking with him, what he did was certainly wrong, but I don't see he's going to have any problem with
Not
these
anymore.
gentlemen, no.
I've dealt with that for 4 or 5 years, people breaking in down there, doing whatever in the world they're doing down there, 2 or 3, 4 o'clock in the morning, hooting and hollering, and walk around with their...
Where's this house located?
Burlington Macedonia Road, right up above Lowe's.
Okay.
And my wife gets out in the yard with her grandchildren and stuff sometimes, and they don't care to expose themselves, so to speak.
Not these gentlemen.
Not these gentlemen, the people who's coming down there.
He just got frustrated, he didn't do the right
Tired
thing,
of
but
it.
he will have no, he's happy they're in there now.
Yeah.
Get some of the riffraff out of the
Well, I
place.
can't make them, it's up to the prosecutor, I can't make them do any particular thing. If
Right, but there'll be no more problems out of me.
I think a 90-day continuance will work. We'll ask for the payment of court costs at the end,
Oh,
and no
absolutely.
problems in the meantime.
Yeah. They're,
And you gentlemen are agreeable to that? In other words, what they're saying, hold
Whatever.
it off for 3 months, but there's no further problems. You'll pay the court costs and the case will be dismissed.
Now, we have to address the issue of the protection order. I don't know, do you all feel the need to continue to have a protection
I
order?
mean, my thing, if I do move into the house, if I got protection, I mean, my house is, this house is here, his house is here, like, I mean,
Right.
we're gonna see each other.
Right.
I don't see no issue.
Nope, not at all.
So you're not wanting a protection order?
No, I mean, I ain't gonna keep the man from being able to walk onto his property or.
Well, I think an apology would be appropriate to say, I'm sorry, I was mistaken, I thought you were there for evil intent, and you weren't, and if I'd known you,
Right.
maybe we can be friends going down the road.
I guarantee it.
Okay.
We're gonna be neighbors, we gotta be friends.
Yeah, I mean, he grew up in the house that I bought, so I mean,
Yeah.
he knows every little detail that I need to know at the same time.
Okay.
Right, and I just made a mistake that day, thinking that there was somebody else down there doing more damage and
So maybe we can change this from a bad situation to a win-win. So you
Oh,
get-
yeah.
You get a
Guarantee
good
it.
neighbor and
Yeah.
you can help each other.
I guarantee it.
he's happy he's bought the house now, to keep like I said, the roof.
Oh, yeah, yes. I'm real glad he bought it.
Okay. Well, let's just let him for 90 days and then it'll be dismissed if there's no further problems and you pay the court costs.
You know, is that cost in both cases or one case?
Mr. Ito,
Well, just one.
one case. So that's October the 10th.
Actually, Judge, I'm going to be in South Carolina, to drive here by Zoom if I need to. I'm
What's
just,
the change today?
okay.
How
I
about
can,
the 17th?
yes, I'm back 17.
Okay, October 17th.
Yeah, I'm coming back Sunday the 12th, and 17th is fine.
Thank you.
10 o'clock. Further problems, we'll get dismissed. You for court costs. It'll be the,
It could be 5 o'clock before we got.
I hate that it happened.
it's like you said, from a real long TV show.
I'll tell you more about what happened, so.
State of Ohio versus Richard Sloan, case number CRB 14630. Richard Sloan, trying this trouble for a bond. Tires case.
Richard Sloan is, well, we're looking for Mr. Sowers. Tell me when did I set, I heard something back from the VA, is that Russell Ferguson guy from Galveston? When did I set him? Was it like 28? For his next hearing?
Likely is him.
I'm gonna write something in this. Steve Stanley. October 17th. I'm just gonna, I'll leave it here. This, I'll withdraw it. Thanks.
need to notify Mr. Sowers again of wrongful.
Oh, yeah. Got sidetracked with the other case.
Warrant was issued June the 16th.
Yeah. And it looks like I put down July 7th. Usually I send him a text saying when the bond forfeiture is. I just sent him another one to remind him.
Normally always gets a copy from the clerk. Who does the warrant, but
State of Ohio recalls Brian K. Schaffer, who's one of the inmates back in the home. Case number KRS 819 A, B, and C.
Okay, so I got some notes here. Valerie Gu apparently did have full coverage, and she's got in litigation with her own company about her damages. So she's going to be out of pocket a $500 deductible, it looks like. So she should get, now, the way this works, if she recovers from Progressive as her insurance company, they have a right to sue you for whatever they have to pay her. But I'm going to order that you pay her the $500 deductible.
So I get out of jail then?
Probably. I don't hear the prosecutor asking for any jail time.
No, you're
Trying to do better, man.
Okay. Anything else you want to tell me?
I would like to like the chest, that we had down in the river, chest street, man, if they help me get my dang license. I all my trouble anymore.
Well, the problem is they can't help you unless you're getting treatment there. I don't think they can just help you get your license. What you can do, I don't know how much they'll actually help, but they're supposed to now. You can go to the local BMV office. There's one in Proctorville, one in Ironton. They're supposed to help you now. Because they've got access to the computers. They can look, put your name in, pull up your history, and tell you what you need to do to get your license back. No, I can't do that.
I'm under suspension, right?
I would say you are, because that's what you got charged with. So
I can't get no license, what you're saying?
Well, the BMV sometimes has these amnesty programs where they'll work with you, but you have to go through the BMV. I'm not gonna, because you probably got suspensions from other courts and other things that have happened. I'm not gonna.
Nothing from other than this state.
Well, I have never done that. I've never said, well, give this guy a license even though somebody else has him suspended. I'm not gonna do that.
I'll try.
But you go to the BMV, that's what you gotta do. Okay, so on the driving under suspension, I'll impose a $100 fine and court costs. It was a non-jailable variety, so I can't give you jail time. You got some jail time for not coming. I'll order you to do 30 hours community service, 2 years of level 4 probation. Your review hearing is going to be January the 12th of next year. So you got to show up down here January the 12th if you don't have things finished, or you go to jail then for not showing up. And And then, let's see, what else did you have?
Said restitution.
Restitution of $500 to Valerie Goo. And her address.
So $500, $600.
You owe her $500. You owe the court $100 fine and court costs.
I don't need to address as long as it's in the.
It's in the file. And then what else? We got a B case, is a stop sign, $20 fine.
I didn't run the stop sign, my windows were fogged up, I pulled out in front.
Well, then you shouldn't be driving if your windows are fogged up. Seatbelt, I'll dismiss the seatbelt because you said you were wearing it in your report, so dismiss the seatbelt.
I'm getting out today.
You're getting out today unless there's a holder from some other court. I'm releasing the holder. So, you go back to Jackson. You live right in Jackson or where you live?
I live in between Jackson and I used to get glasses.
Okay. All right. You're welcome. You're welcome.
State of Ohio versus Tasha N. Atkins, case number CRB 2587 A and D. Your Honor, she has reported for jail. It's ordered.
Okay. She has a review hearing December the 12th.
State of Ohio versus Norman Castro Angelo, case number TRC 2515-04 A and B.
Well, I think he might interpret. Are you going to interpret?
No.
Okay.
Sorry, I thought I was pointed out that way.
No, hablo español. Do you speak English or Spanish?
No, sorry, later, speak English.
Oh, we've got an interpreter on the line. Okay. Interpreter, could you identify yourself, please?
I've seen.
Yes, Your Honor. My name is Rolando with Language Line Solutions. My ID is 258476.
All right. Rolando, is that the name?
That is correct, Your Honor, yes.
Okay. All right. I've got Northern Castrolongo. Is that even close? All right. Tell him that he is charged with driving under the influence and having an open container.
Soy el señor que tiene cargos por manejar bajo los efectos del alcohol y tener un contenedor abierto.
Lo del contenedor abierto sí es cierto, pero no estaba bajo los efectos del alcohol y drogas.
About the open container, that is true, but I wasn't under the effect of alcohol or drugs.
Okay. I'm going to take that as a not guilty plea. Ask him if he wants a court-appointed attorney.
Está bien, entonces voy a tomar eso como una declaración de no culpabilidad. ¿Usted quiere un abogado asignado por el tribunal?
No sé la verdad qué hacer. Yo quiero que esto se termine ya.
I really don't know what to do. I just want this to be over.
Well, that's not happening. So I'm going to enter a not guilty plea.
Eso no va a suceder, entonces voy a introducir una declaración de no culpabilidad.
Does he want a lawyer appointed?
Can you ask him if he wants a lawyer appointed?
¿Quiere usted que se le asigne un abogado?
Sí, ¿por qué no?
Yes, why not?
Does he have a job?
¿Tiene usted un trabajo?
No, señor, por el momento no.
No, sir.
All right. Where is he living locally?
¿Y dónde está viviendo usted localmente?
En Huntington, West Virginia.
I'm going to appoint,
Virginia.
yeah, I understood that. I'm going to appoint Luke Steyer to represent him.
Voy a asignar a Luke Schaffer para que lo represente.
There's nobody out
Oh,
there,
yeah.
Judge.
Do we have a card? I've given you a card of your attorney so you can contact him, and then I'm going to set a hearing date for you.
Le estoy dando una tarjeta de su abogado para que lo pueda contactar y voy a agendar una audiencia en el tribunal para usted.
July 28th at 10 a.m. will be his next hearing.
Julio 28 a las 10 a.m. va a ser su próxima audiencia.
Julio 28.
July 28.
Sí, ok, sería todo por ahora.
That'll be everything for today.
Okay, do you have any questions? Oh, he can sign a signature bond of $2,000, which means as long as he comes to court, he doesn't have to post the money. He's guaranteeing his own appearance.
Está bien, entonces puede firmar una fianza de $2,000 de su propia responsabilidad. Eso quiere decir que no tiene que dar el dinero, nada más tendría que venir al tribunal bajo su propia responsabilidad.
O sea, solo tengo que firmar.
So I just have to sign?
Yes.
So,
Sí, sí.
I'm sorry. Okay, that's all for now. Time to be back here on July 28th.
Eso es todo por ahora. Regrese aquí el 28 de julio.
listo, en verdad, muchas gracias, muy amable.
Thanks very much.
All right, thank you. Thank you for translating. Okay, on Richard Sloan, I'm going to continue that for Gary until next week, July 14th, on bond forfeiture.
Your Honor, the one thing we're waiting on is urine screen from Austin Hawthorne, and he has not put out through that screen yet.
Okay?
That would know.
Well, we'll put it off until Friday then, since he hasn't provided it, he'll do it Friday. Hold him on a bond of $2,500 cash assured. If he does one, we can go ahead and screen him before then, but
That's not today.
he hasn't provided it yet, so I'm going to say he's going to be very,
We're finished.
court's adjourned.